Folks, thanks for your patience. I've been doing this a long time. We've never had an issue with this recording technology. Today it decided to act up, so it'll be a few minutes and then we'll get started. The Honorable Judges of the United States Court of Appeals for the 10th Circuit. Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near, and they will be heard. God save the United States and this honorable court.
Morning. Please be seated. Ms. Warble, we don't have any preliminary matters, do we?
We do.
Oh.
I'm here this morning, Your Honor, with a preliminary motion to swear in 4 new members to the bar of our court. With your permission, I will introduce the candidates. Would our candidates for admission please approach the lectern? We have 4 candidates for admission this morning. Zoe Rubin, one of your law clerks, Judge Bacharach, a graduate of Yale Law School and a member of the New York Bar. We also have 3 of Judge Shelby's law clerks, Rebecca Buchert, a graduate of the University of Utah, S.J. Quinney College of Law and a member of the Utah Bar. Andrew Yablonsky, a graduate of the Georgetown University Law Center and a member of the New York Bar. And Kendall Archer Graves, a graduate of the George Washington University Law School and a member of the Utah Bar. Before I make the motion and administer the oath, are there any questions or comments from the bench?
Leave
it to the two of you.
Hers might take about 30 minutes.
Long. Sorry. Go.
I don't have a question, but I do have an editorial comment. It is such a privilege and a delight and an honor to work with Zoe. And for Rebecca, Andrea, and Kendall, I assure you that you could not have found a better mentor in the United States. And so congratulations to you, not only for joining the 10th Circuit Bar, which is itself an honor, but an even greater honor to work with my friend and colleague and one of the most wonderful judges that we have in our country, Judge Shelby.
I respectfully move for the admission of these candidates to the bar of the United States Court of Appeals for the 10th Circuit. May I administer the oath?
You may.
Please raise your right hands and repeat after me. Would all members of the 10th Circuit Bar please stand and silently renew your own oaths? I do solemnly swear or affirm
I do solemnly swear or affirm
that I will conduct myself as an attorney
that I will conduct myself as an attorney
and counselor of this court
and counselor of this court
uprightly and according to law,
uprightly and according to law,
and that I will support the Constitution of the United States.
and that I will support the Constitution of the United States.
Congratulations.
Thank you.
Okay, we have 6 cases on our docket, 5 of which will have argument. We'll let you know after the second and probably the third case if we're going to take a short break. But our first case this morning is a case called Young versus Colorado Department of Corrections. Mr. Trackman and Ms. Nelson, I think, are representing the appellee. So we'll hear first from Mr. Trackman, please.
Good morning, Your Honors, and may it please the court, William E. Trackman for Appellant Josh Young, who is here with me in the court today. I'm going to try to reserve 3 minutes for rebuttal. After Justice Jackson's decision in the Ames decision last year, we know that Title VII and 42 U.S.C. 1981 apply equally to Mr. Young as a Caucasian person as they would apply to an African-American employee, an Hispanic employee, a female employee, or a gay employee. In other words, the fact that the training at issue here is called DEI or EDI training does not alter this court's inquiry.
Sorry to interrupt so early, but about the impact of Ames. Now, Ames was a zero-sum game. There's 2 people applying for a job, a female homosexual, a heterosexual. One of those individuals is going to get the job, and the disposition was just as you identified it in your brief. Does that apply equally to a hostile work environment? You know, for example, if you were to take this set of facts and say this panel is sitting not only in 2026, but in 1960 or in 1860, on the heels of a civil liberties movement where there was great discrimination and interference with educational opportunities for, blacks, or to take an even greater example, or a more extreme example, the Reconstruction era in the aftermath of the Civil War. Would you still say that it was, that we have to be completely agnostic, treat racial majorities and minorities equally as we did as the Supreme Court did in Ames, where you have two people applying for a job and saying that favoritism based on sexual preference is, an improper consideration? Does that mean that we are completely insulated from our history, and that we can't consider the fact that there have been educational impediments to minorities?
Well, 100% yes, Your Honor, on the first part of your question, which is you are agnostic as to the race of the plaintiff. That's Ames. Now, Ames is at heart a textualist decision about what Title VII means, and it says that judges can't treat plaintiffs differently for a Title VII inquiry based on the race of the party who comes before them, and I think that 100% applies to a hostile work environment claim. Now, there are other cases, I think Oncali is cited by the district court, that say you can take historical circumstances into account sometimes to decide how offensive something is, and I think that's a little bit of a different inquiry, and maybe that's the second part of your question, but we would say that the court shouldn't do that at the motion to dismiss stage. Mr. Young has pled over and over again how the training itself was offensive to him and to any Caucasian person, and then also how that affected the workplace in a way that was toxic, that created safety risks. And so to answer your question directly, you are agnostic as to Mr. Young's race. You can look at the four corners of the complaint and say, okay, this survives a motion to dismiss. Maybe at the motion for summary judgment stage or at the trial stage, the state can say, look, it's not really offensive if you use the full N-word, if you're talking about a white person thinking about black people as the N-word. That's different, but we think that's a question for a jury, not a court on the motion to dismiss stage. Thank you. So under Young 1, we acknowledge that it's not enough for a plaintiff to state a hostile environment claim, even if an employer has virulently racist training materials, including even the full use of the N-word in the training materials. That's the ground as we take it under Young 1. So the question is, what more is needed to state a claim to survive a 12b6 motion? In Young 1, the court said that a single training isn't enough, but perhaps an ongoing commitment would be enough. It also said that while the training, yeah.
Judge Tipovich say an ongoing commitment, or did he say that if there was a repetition of the offensive EDI training? In other words, if he said, I don't remember, and you may be right, but I don't remember Judge Tipovich saying that, well, if they said that this EDI training was problematic, and he certainly indicated that, but I don't recall anything saying, well, if the plaintiff had alleged that they were going to repeat EDI training in the future, that would itself inherently mean that now there is a hostile work environment. In fact, arguably, he said the opposite when Mr. Young alleged that he was going to be jeopardizing safety by second-guessing his own decisions when they would be subject to second-guessing based on racial antagonism, and he called that speculative.
Well, just to be clear, Your Honor, we view Young 1 as laying out 4 independent markers for how you can supplement the mere allegations relating to the training materials. This is one of them. I do think that the decision says perhaps an ongoing commitment. Maybe one of us is wrong, but the idea is that if you have an employer who says, I'm going to teach you racist concepts today, and you can count on the fact that they're going to be repeated in the future, you don't have to wait for the annual training to reoccur. The second marker is that even if the training itself talks about your deficiencies and your inadequacies based on your race, that's not enough, but if the employee is required to endorse such viewpoints, that could change the inquiry. The third is that if an employee is able to show that the training was acted upon within the workplace, that might be enough. And fourth, that if there is a safety issue within the workplace, that itself might be enough. So with respect to the first inquiry, absolutely, we do think there's an ongoing commitment here, Your Honor.
questioning the ongoing commitment aspect of it too. My understanding was they talked about ongoing training and a certainty of ongoing training. I don't think you have anything here beyond a single training, a single online training.
Well, respectfully, Your Honor, we do have a single online training, but then we have a complete paradigm shift within the prison saying you are going to have to integrate this training in your day-to-day routine decision-making. That's part of the modules that says you don't need to wait for any more instructions. This is part of your job now.
Single online training in terms of the severity of that event, I guess is what I'm looking at right now. I mean, you've got to show either severity or
Pervasiveness.
right, pervasiveness. You've got to have one or the other, and I guess I would ask you, what do you have to show in terms of severity?
Well, in candor, Your Honor, we view young one as cutting off severity. So we're
right.
talking about
All right.
pervasiveness
I
here.
appreciate that.
Yeah,
Okay.
we have preserved for appellate review, further appellate review, the idea that it's,
Pervasiveness, if you have a single event, and even if you have a commitment, to maybe some ongoing training that's not planned and hasn't happened, what do you still have in terms of pervasiveness with respect to training?
well, again, this training was meant to be a paradigm shift. So it involves the bystander intervention process where if a non-Caucasian person is interrupted, the employees have to stop and say, hold on, we need to make a correction here. The conversation can't continue. It involves meetings policies where women and non-whites have to speak first at meetings, where that has to happen, that discussion has to happen before the meeting starts.
This was all in the training.
This is
Yeah,
what
yeah.
the training
Right,
requires
right,
in
right,
day-to-day.
yeah.
Yes.
Yeah, in terms of his own experience, though, in the workplace, as far as pervasiveness, what events or instances of harassment have you pointed to in terms of his own experience,
Right. So
objectively, not subjectively, as to how he was feeling or what he thought this might all mean
Sure.
to him, objectively?
So we lay out 9 instances where this training affected the workplace. So performance reviews were immediately changed.
But I'm asking about his own experience.
So
Not just generally. What was his experience in the workplace? Did his performance review somehow decline, or was it impacted in some negative way that objectively would have been something he could?
The performance review is not in the, apologies, Your Honor. The performance review is not in the record. We don't have that from the state yet, but we do have Josh Young's, his job suffering. He was having a harder time keeping contraband out of the prison. He himself.
I don't think he said he had a hard time keeping contraband out of the prison. I think he did not give a single instance where he did not think he kept it out of the prison. He talked about his subjective feeling about being concerned when he was, I guess, processing people who are entering the prison.
The
But
complaint.
he didn't talk about there being any instance where he said or that anyone objectively observed that. It was just a feeling that he had that he was concerned, apparently.
Well,
He wanted to make sure he didn't do anything he shouldn't be doing.
The complaint says it made his job of keeping contraband out of the prison harder because he was constantly paranoid that people were going to say, why are you searching this person? They're a black person. You know from the equity continuum that you have to treat this person differently based on your workplace training.
Okay, so subjectively he felt that way. Is there anything objective there that anyone could have observed, or that someone said something to him that made him feel that way?
Well,
or he...
His friend, Mr. Gillis, said that his job was also getting harder because he couldn't prepare prisoners for release adequately. That's paragraph 80.
To focus in on the plaintiff here.
Okay. He saw innocent remarks in the prison getting challenged based as contradicting the training itself. And the fact that he needed to use force.
Those remarks made to him?
No, we don't plead that he was insulted or ridiculed, right? But
Just his observations.
right. But the test is not insult or ridicule in a vacuum. It's also intimidation, and it also relates to the terms and conditions of your employment. So you don't have to actually suffer a secondary insult based on the training from one of your colleagues. So we've identified those, and again, Young himself. I realize that there are some some description in the district court opinion about how these were subjective, but we view these as objective. The fact that Mr. Young had a more difficult time keeping contraband out of the prison is an objective factor that came from the fact that he was interacting with people of all different races and was told from the training, you need to treat people differently based on their race. Second, if the training weren't actually affecting the workplace in a widespread way, why would he file his complaint? So he filed his complaint in July of 2021. The prison system summarily dismissed it without any investigation. They said, we're not even going to investigate the allegations you've made that this training is creating an unsafe working condition. We do cite several cases talking about the failure of an employer to even investigate an allegation of hostile work environment. We think those are not responded to at all by the defense. And we would say that absolutely, this is notice pleading. We have survived a motion to dismiss. Maybe at the end of the day, these allegations won't survive a motion for summary judgment, but for getting over a 12B6 motion, we have adequately pled not just the training, but also the effect on the workplace. With that, I'll reserve the remainder of my time for rebuttal.
Matt, do you mind stopping the gentleman's clock? Nancy, do you have any more questions?
Go ahead.
Good for now, thank you. Okay. Thank you very much.
Thank you.
Mr. Nelson, I apologize for mistaking the gender.
No worries, Your Honor.
You can call me Mrs. Bacharach if you like.
Good morning, and may it please the court. My name is Pavan Nelson, and I represent the Appellees. This is a straightforward case. In order to bring a hostile work environment claim, a plaintiff must plausibly allege that their workplace is permeated with discriminatory intimidation, ridicule, and insult that is sufficiently severe or pervasive to alter the conditions of that person's employment, from both a subjective and an objective standpoint.
What if the training said white people are inferior to black people or to Hispanic people, whatever, you know, pick your pejorative poison. And they say, as the amended complaint says, that training is going to be factored into your evaluations. And then they say, as the complaint does, that the EDI training will be repeated every year. Now, this is unlike a lot of hostile work environment cases where there are individual employees who make very insulting, pejorative remarks. This is more like, let's say, an analogy of a civil rights case, a Monell claim. This is a policy. This is how we are going to train every single supervisor, guard, correctional officer. And so, in that case, liberally construing the complaint, why wouldn't the official adoption of this policy that is going to be factored into your not only your training, but your raises, your bonuses, your evaluations, why wouldn't that survive the very low standard under 12B6?
Well, Your Honor, I think the court said it best in Young 1. As the court explained in Young 1, simply characterizing something as an official policy is not necessarily sufficient to bring a hostile work environment claim. There needs to be a demonstration, well-pleaded facts, that there is racial animus manifesting itself in the day-to-day working environment. And not only racial animus, in order to meet the high bar for a hostile work environment claim, it needs to be a steady barrage of opprobrious racial comments. The court explained that in Young 1. This has been a well-established standard in the hostile work environment context for decades. And so, again, the comments you said, problematic, obviously, but you know, stray comments are not enough to meet that high bar.
Well, that's and I don't mean to belabor this, but can I drill down on stray comments and whether or not that sort of gets at the nub of what I'm struggling with? Is this a stray comment, or is this the official implementation of arguably improper policy? For example, let's assume that I am a religious minority. Let's say hypothetically I happen to be Jewish. I am Jewish. So I apply as a guard, and the training says, pick your pejorative epithet about Jewish people. And it says, this is the training. This is going to be factored into your evaluations. And this is going to be factored into your quarterly performance reviews, as the complaint says. This is going to be repeated in the future. Is it fair under 12b-6 with liberal construction of complaints to say, well, that was just a stray comment, that was just some line in a training policy, or is it something more qualitatively more severe? Is that this is how you are to understand your job? This is how your supervisors are to understand your job. This is going to affect your livelihood. This is going to affect your evaluations, your ability to avoid termination, suspension. This is going to affect your bonuses. Can we really derogate this and say, well, this is just, the equivalent of somebody saying an improper epithet about Jewish people?
I think you can, Your Honor. I think the standard it's pretty well established. And I think the Court in Young 1 explained it. Again, there's an objective standard here for a reason, right? It's a high bar to make a hostile work environment claim, and subjective fears about the future, about what might happen, that's not enough to demonstrate that there was a steady stream of opprobrious racial comments, that the workplace was permeated with discrimination. And to go into your specific comments, I think if you really drill down and actually look at the allegations in Mr. Young's complaint, that they're conclusory allegations about his subjective beliefs. You're talking about his, the performance reviews. He feared that he would get a negative performance review. Without providing any factual enhancement, he says he was assured that they would be factored in.
Actually challenging that his subjective fears were certainly reasonable based on what he had learned through the training.
Well, no, Your Honor.
Saying it matters or not, but are you challenging that his subjective fears are reasonable? And I'm kind of trying to play out this line between subjective and objective too, when you actually have something that you can see and feel and look to, which is this training, which has some objectionable matter in it. That's something we can all look to as a reasonable person. What do we think about that, and how a person would react to that? But then we're basically looking now at his reactions to it as subjective, his subjective behavior, his subjective views, and maybe that's not fair to do that when it's pursuant to the company's policy that he has these fears.
So no, Your Honor, I'm not challenging that Mr. Young has pled that he had, subjectively that he felt that that his environment was hostile. I'm certainly not challenging that. He's pled that. I think our point is that's not enough to sustain the claim. As the court explained in Young 1 and as the district court found, there needs to be an effect on the workplace, racial animus manifesting itself in the day-to-day working environment due to the training in order to sustain the claim. And that's really what I'm focused on, that there's really no well-pleaded allegations in his complaint that demonstrate that. And your back and forth with Mr. Trachman when he was up here, I think demonstrates that.
Well, the plaintiff said he had fears as he was doing, when he was screening people. He didn't want to appear as biased or to be treating anyone differently, and he thought about that. And he didn't necessarily say there was a time when he missed something, but how does he even know that, I think, is the problem. How does he know how this is potentially impacting who he's allowing into the prison?
Well, I think there has to be something.
Can he show anything there?
Yeah, I think there
as
has,
a result of his fear, other than his fear that he's living with, and in his view is permeating his workplace.
yeah, I think it is possible, Your Honor. When you look at other cases in the prison context where there's a hostile work environment that has been adequately alleged, they have demonstrated, in addition to these fears, that there was something done in the workplace that affected workplace safety. So in their brief, Mr. Young cites the Dawson case, which is a Second Circuit case in the prison context where a supervisor circulated obscene and violent letters written by inmates about the female prison guards around the prison. And again, there was actions by the supervisor to undermine the safety of the female officers. In that instance, the court said, that's enough to demonstrate pervasive harassment. There's another case, I think it's cited in a district court's order. I think it's Semroth. Wasn't in the prison context, but it was a law enforcement context. In that case, same hostile work environment, female officers, they alleged that the co-workers failed to back them up in emergencies. And that was the objective element that demonstrated that there was a safety risk besides their subjective fears. And I think when you contrast those cases with what Mr. Young's alleging here, it's not the same. It's only just, he was afraid he might be written up based on his interpretation of the training, and there he was hesitant and second-guessed himself sometimes.
That all seems reasonable that he felt that way,
But again, there needs to be, again, I think as the court, the standard is pretty clear that is more than just subjective fears. It has to be an objective component as well.
can have a policy, or the Department of Corrections can have a policy, but it can't be pervasive type harassment until somebody actually does something or enforces the policy or disciplines someone or calls something to their attention and makes them, objectively feel uncomfortable. And you see what I'm saying?
Yes, I see exactly what you're saying, and I think the answer is yes, Your Honor. I think that's what the lesson was in Young 1, and I think that's what the lesson is in cases where they have found that a plaintiff plausibly alleged a hostile work environment claim. And several of these cases have been cited. It was cited in Young 1 and in the district court order. DiPiero, Deemert, Johnson. Mr. Young submitted a supplemental authorities, the Chislett case. This is a Second Circuit case where, in that case, multiple EDI trainings, there were allegations that coworkers repeatedly used the comments from the training against the supervisor, the plaintiff. When the plaintiff complained, the plaintiff was demoted, was taken away from supervisory responsibilities, repeated EDI trainings, repeated comments from coworkers, and at the end, after she complained, she was criticized so roundly that she went on short-term disability for emotional distress. And I think those are examples of adequately pled hostile work environments claim. And when you compare it to the allegations here, it just simply doesn't match up. It's really conclusory allegations about his subjective beliefs, and that really is not enough.
Could you respond to the discussion about what our prior opinion said on the training and what might be required? It was dicta, of course, but I did find it in footnote 2, and I think Appellants Counsel did accurately characterize it. It said, perhaps, and that's a big perhaps, obviously, an ongoing, continuing commitment from Mr. Young's supervisors to mandatory EDI trainings with content similar to the one here may evolve into a plausible hostile workplace claim. Was there an ongoing, continuing commitment from his supervisors to mandatory EDI trainings?
No, there's not, Your Honor. I don't think there's any allegations in the complaint that a supervisor actually said anything to that effect. It was, he expected it to recur. So again, that's, he believed it, but there's nothing objectively. There's no comment from a supervisor that said that. And just to back up a little bit, Your Honor, you called it dicta, and I think it's important to keep in mind, like, the discussion itself. In the employment discrimination context, there aren't really per se rules like that. If you check this box, you're automatically in, right? And I don't.
Well, it's dicta, obviously, but it also started out as perhaps.
I agree, Your Honor. And I think the Twombly-Iqbal standard kind of goes to this, threadbare recitals of causes of action don't suffice. And I would say here, threadbare recitals of that footnote is not enough to push it over the line. Again, you need to meet the standard, the severe pervasive standard. There needs to be permeated with this discriminatory conduct, racial animus, and none of that is really in the complaint, Your Honor.
Assuming arguendo that that one of us might question whether or not it really is just a conclusory allegation, how do you interpret paragraph 8? He took the training in March 21, soon after it was assigned. Like all other assigned training, the material from the EDI training was expected to be used every day at work. That doesn't seem like a lot of what we day-to-day see as conclusory allegations. It's not terrible, inherently implausible for an employee to say, my boss gives me training every single year, doggone it. Every year, the Colorado Bar Association makes me do this, darn CLE training. It's not necessarily conclusory to say, well, I think the Colorado Bar Association is going to make me take a bunch of CLE next year. And it seems like that's what it's doing in paragraph 8. So it was expected to be used every, the material for the training was expected to be used every day at work. And then he elsewhere alleges that that he was assured that the training would happen each year.
So, I'll say quickly, Your Honor. I would argue that there's no factual enhancement there, so those are conclusory. But even if you think they're well-pleaded allegations, I think the lesson from Young 1 is, again, there needs to be a tangible impact of racial animus in the day-to-day working environment. And you look at the training, for example, Mr. Troutman mentioned, meetings, who speaks first in meetings. But there's no allegation that that was actually applied in any meeting Mr. Young actually attended. It's just there's no allegations that any of the aspects of the training that he found objectionable actually showed up in his day-to-day working environment.
But doesn't he plead that it did? Isn't there an employee of color who is under some sort of reprimand procedure and then gets relief that Officer Young ties to the training? He's consistent with the training in his view?
Well, respectfully, Your Honor, I don't think that's a necessarily well-pleaded allegation that would support a hostile work environment.
Could you speak up just a little bit or closer to the microphone?
I
You have a soft
apologize.
voice, sorry.
I apologize.
Thank you.
I don't think that's a well-pleaded allegation that supports a hostile work environment, because essentially what he's saying is an unnamed officer at an unknown time successfully challenged some unknown discipline against some unnamed supervisors that had nothing to do with Mr. Young. And Mr. Young came to the conclusion that the training affected the environment. I think that's conclusory. It doesn't demonstrate that he was being harassed, and I don't think that's enough to support a hostile work environment. I see my time has way elapsed, so unless the court has any other questions for me, I would just respectfully request that the court affirm the district court. Thank you.
Okay, thank you very much. I do think the appellant has some rebuttal time.
Thank you, Your Honors. I think my friend's argument amounts to the fact that an employer could have official training materials that says Negroes need to grovel at the feet of Caucasian colleagues, and starting tomorrow, and the next day that could happen, and an employee who's African-American could say, I feel uncomfortable, I shouldn't have to grovel at the feet of my colleagues, and that would still not suffice to create a hostile work environment, because no one's calling that person a name, no one is saying your job duties have to change. I'm Jewish. I'll just say, if I went to work for an employer who said every colleague needs to spend their first 15 minutes on the job thinking about a final solution to the Jewish problem, I would feel uncomfortable if that starts tomorrow. What is the next thing that I have to do? The training under Young 1 might not be enough, but I really don't think we need to say a lot more has to happen in the workplace before a plaintiff who's subjected to that kind of training material, official policy from the workplace, is able to survive a 12b6 motion. So, in Young 1, the court said, this training sets the stage for actionable conduct. I mentioned in my initial opening remarks, this was a complete paradigm shift in the prison. They had micro-affirmations, they had bystander interventions. They told you that you needed to incorporate this training in your routine, day-to-day decision-making, that it had to be fully integrated in everything you do. So no surprise, yes, Your Honor, that Mr. Young saw a low-level corrections officer being disciplined jointly by a lieutenant and a sergeant, and then when that corrections officer said, "I'm being discriminated against based on my race," it was reversed. Mr. Young attributed that to the training. I don't think that's an unreasonable attribution. At least it's enough to survive the 12B6 motion. Let me also talk about a few notes. On ER 748, I think, Your Honor, Judge Moritz, that ongoing commitment language, it does say perhaps, but again, that's one of the four markers that I think the Young One court laid out. It is the ongoing commitment, the employee endorsement, the actual actions by your colleagues, and then also the safety issue, and we've pled all four of those markers. And last, I think on liberal construction of the pleading, I think that Your Honors have embraced that standard and the district court expressly rejected it. Thank you so much.
A question about, before you surrender the podium. So I just want to make sure I understand your argument. You're not saying that if the training itself amounts to the adoption of a policy, that that's enough? That you don't need to supplement those, that theory with specific allegations showing that the policy is implemented in the workplace in a way that changes the working conditions?
That's Young One, Your Honor. So we take Young One as we find it. So yes. Thank you.
Ask one other question before you leave, and I think it's a short question. May or may not be a short answer. But I just had a question about two of the items that Judge Timkovich was troubled by in Young One. One was the redlining video, and the second was the claymation. As I understand it, both of those were in videos that were linked in Module 4. But as you point out in your complaint, I don't mean to point at you, in the complaint, it does specifically acknowledge that on page 7 of the transcript, it specifically says, as the module says over and over again, that these are additional videos that may or may not be pertinent to your day-to-day work here, and none of these videos are either approved or endorsed by the state of Colorado. And so, even with liberal pleading, you have specifically pleaded, as I think we're obligated to do, to acknowledge that the state of Colorado doesn't even endorse or approve any of those videos. So how can we take those videos even into account when we analyze the case? That's been nagging at me. So
Thank you, Your Honor. So respectfully, there were some outside materials where the training disclaims whether it might be relevant. That's not what the recommended trainings were. In Module 4, where they say other recommended trainings and readings, that was a link that was blessed by the state of Colorado. So it's not
Module 4 was.
Right, but the links in Module 4 are ones that say these might enhance your experience and you should use these in order to gain knowledge about it. There are other materials saying these are just out there, but those are not the links that Your Honor is talking about. So
Saying that the redlining and the claymation videos are in videos in Module 4 that said you need to look at these and that these are endorsed by the state of Colorado?
So to be clear, they don't say these are endorsed, they say these are recommended. And then there are other materials that are just linked. And the state of Colorado says, you could take a look at these if you want, we don't endorse them. But the redlining video is not one of those. It's not one of the videos where they say, take it or leave it. It's specifically in the other recommended. And when Mr. Young filed his complaint and they responded to him, they said the required materials that you are referring to were taken by everybody. So, yeah.
Thank you for indulging me.
Yeah.
You sure? Thank you very much, counsel, for both sides. I think I speak for the panel when I say that the briefing and the arguments were excellent, and we appreciate your wonderful advocacy in writing it in today. This matter is submitted. This we'll hear, in just a moment, the estate of Kevin Dizmang versus Reed, and this is 25-11-18. Fancy is this stuff at your right. We'll hear from the appellant whenever you'd like. You're going to alternate? That's right. Alternate at your own risk.
Good morning, Mayor. Please the court. My name is Harry Daniels, and I represent the appellate sitting at the table, Ms. Kendra James, who she is the administrator of the state for her father, Kevin Dizmang. Your Honors, we appeal this case from the district court because we believe the district court erred and failed to consider that the act by one of the appellate Fisher, the paramedic, act was egregious conduct, that it was so egregious that a case directly need not be directly on point, nor a case in the 10th Circuit nor the Supreme Court to determine if this was a constitutional violation. Your Honor, we're talking about a case dealing with a person who shows signs of oxygen deprived, breathing, that was in distress, breathing, hypoxia, and the paramedic who we believe, based on the allegation and complaint, is somebody who is trained to identify those medical issues. Instead, this paramedic tackled Mr. Dizmang, as alleged in the complaint, and wrapped his arm around his neck, that we tapped him out to a chokehold that resulted into the death of Mr. Dizmang. I believe that is undisputed at this time in the allegation and complaint, particularly as we allege that 5 doctors opined that the cause of death was due to physical restraint. We are aware that the district court's position as it relates to whether there's law clearly established. And I think that when you have an act so egregious as this, that I think this is directly where we talk about the Casey case in Capitol Heights. We talk about a sliding scale where this court should not be waiting for a case directly on point or similar to determine if this was a constitutional violation. I think this case really tantamounts to the acts of Appellate Fisher, kind of tantamounts or where a doctor goes into a hospital room and see a patient struggling to breathe and takes the oxygen mask away from them. Now, obviously that didn't happen, but we're still talking about restraint that restricted Mr. Dizmang oxygen and breathing that resulted in his death. I think one of the things that the district court determined that the appellants did not show in the allegation that the Appellate Fisher was engaging in law enforcement functions. I believe based on the reading of the complaint, of course we had the motion dismiss stage where the allegation and complaint should be accepted as true, and like most favorite to the non-moving party, the appellants here, where you have in the complaint the acts, the allegation of what transpired with Appellate Reed, the officer who responded as well, where he was ordering Mr. Dizmang to put his hand behind his back. He initially told him to sit down, and he told him to put his hand behind his back. Mr. Dizmang was resistant. Then he basically escalated and told him to put his hand behind his back. Mr. Dizmang fled. I don't want to say he fled, but he walked away from him, which now the appellee Fisher tackles him to the ground. And when you look at this complaint and you even go after the fact and you look at the dialogue within the hospital setting and the question by one of the nurses asked Mr. Fisher, and it says, you arrested that boy. And Fisher says, no, the cop did. He was chasing him, but we lost him between the little grove of trees. So I was like, and he shrugged, and that's when he tackled him. So even if you draw an inference from that statement, which I don't think you have a draw of inference, I think the facts within the complaint really shows that he's talking about arresting, detaining Mr. Dizmang in this situation.
Or what if he's trying, go ahead, Judge.
Go ahead, Judge.
What if as a paramedic, it's his view that there's someone who's not acting rationally, they're near a road, there's safety risk either to Mr. Dizmang or other people around him, and he's using his medical judgment that the individual needs to be restrained?
Well, that could happen, and in fact, it's a case within this district, and I believe this I hope I pronounced it right, Van Langenham versus the city of Oklahoma. It's a 2022 case in the Western District of Oklahoma. It's kind of instructive here, where a paramedics in that situation restrain.
Brief, or did you cite that in your brief?
Yes,
I just want to make
it's
sure.
within the
Thank-
brief,
thank
yes.
you. Yeah.
Where the paramedics, in fact, was trying to restrain the person in order to do their job. And the district court in that case said, well, we don't find this a seizure under the Fourth Amendment because they were trying to restrain. And they really turned on the issue of who initiated. Was it a seizure? Was it a restraint for medical purpose? And in that case, the paramedics initially were by themselves. They were alone. They were not, law enforcement wasn't there at all. A law enforcement eventually came to the scene, and the paramedic asked the officer, could he put handcuffs on him so we can continue to do our job? That's a different fact pattern here in this case. The first person that engaged Mr. Dizmang was the officer. And in fact, and I know the district court said he relied on the complaint, and I know that the videos were also submitted in this case. But even if you look at the video, the officer he tells him, I'm giving you an order. This is an order. This is a lawful order. When you're talking about lawful order, you're talking about a seizure at that point. I think we pointed to the case.
Reed,
Right.
I thought you were talking about paramedic Fisher earlier.
Well, we believe paramedic Fisher indicted, he basically, in this case, assisted and aided Officer Reed in the seizure of Mr. Dizmang here. And I think one of the things that need to be really fleshed out is whether we're talking about a seizure or we're talking about a restraint for the purpose to provide medical treatment here. And I think that's what the district court kind of decided, like this is more of a medical restraint versus a situation of where Fourth Amendment, the seizure would come in. And in our position that when you look at this complaint and you look at the acts of Officer Reed and Appellant Fisher, where he engages with Officer Reed to seize him, to place him under arrest, detention, whatever you want to call it, then he now is shifting away from providing medical care. In fact, throughout the course of the complaint that we allege, he didn't even provide medical care at all.
Isn't the whatever you want to call it the whole bit here? I mean, that's the entire question, is whether the paramedic is acting with an intent to provide medical services to the individual or whether it's with an intent and purpose to arrest or to prevent unlawful conduct or to effect an arrest. There's no allegation about that in the complaint, is there? About paramedic Fisher's intent.
Well, I think paramedic Fisher's intent is relevant here because you look at objective, reasonable standpoint, what was taking place at that time. And we're really, at this point, just talking about a complaint. And the complaint alleges at that time that Officer Reed was engaging in seizing Mr. Dizmang. And if you want to really look at the intent element of this case and say what was his intent, I think if you look at the intent, he didn't provide any medical care, and he said that they were trying to arrest Mr. Dizmang. Well, he didn't say it, he acknowledged that the arrest was taking place.
The other circuits that have taken this issue up are related issues with paramedics in similar situations draw out this complication because there's this overlap. If you've got someone that needs to be restrained so you can provide medical services, then the question is, well, is the restraint to provide medical services or for some law enforcement purpose? And you say that this is a case that's so extreme that you don't need to point to similar case law, but in fact, well, how do we deal with the issue that all the case law that appears to exist in the other circuits cuts the other way? What do we do with that?
Because I think when you look at the fact patterns in this case, you got to look at the facts in each case, not just the over broad sweep. And you look at the facts. And the facts in this case, you have a person that's struggling to breathe. You know, the issue is he can't, I mean, he's hunched over, he's oxygen deprived, he barely can speak because he can't breathe. Then you have a paramedic, a trained medical person, who in fact engages and inflicts a act on this individual where he used a maneuver that restricts his airway that leads to his death. I think when you look at those other cases,
Standard of care as a medical provider, or is it a law enforcement act?
well, it's a breach of, it's both. It's actually both. It's a breach of standard care, and when you engage in law enforcement acts, then absolutely, then it carries over to now you engaging in a seizure. And I think that this court's already determined that it doesn't really matter the title of the person. In fact, in Jones versus Hunt, a 2005 case, this court explicitly recognized that the Fourth Amendment applies to social workers applying the same objective and reasonable standard used for police that demonstrates excessive force analysis is not limited to law enforcement personnel. That's a 2005 case. I don't think it's brief, but it's Jones versus Hunt. So when you look at that case is not even dealing with law enforcement. It's dealing with a social worker. So I think when we get into this, what was the intent? What was the intent of the paramedic? Particularly, what was he doing? We had to look at objective standard as to what took place as alleged in this complaint. And we believe this complaint meets the plausible standard, Iqbal and Twombly 2 standard, that shatters that he was engaging in law enforcement practices.
Couple of questions that go beyond. I think I understand your argument that you have made, objectively, you have given facts that would indicate at the dismissal stage
Correct.
that this was a seizure because the intent was to restrain, not to do something else like provide medical services.
Correct.
But my concern is, first of all, the district court here didn't go beyond the seizure question. It found as a matter of law there was no seizure and there couldn't be. I guess my question to you is, if we go beyond the seizure and say, yes, there are at least at the motion to dismiss stage objective factors that would support the seizure, we don't have a determination by the district court here of reasonableness.
That's correct. The courts,
Back is my question.
and I believe on those grounds alone, it could be sent back because you have an A and a B. The court shouldn't even get past the A to even determine the B.
Can we get to reasonableness?
Well, I believe that based on the,
Court make enough fact findings that we could get to reasonableness ourselves?
well, I think based on the complaint itself and within the confinements of the complaint.
That's right, I don't mean fact findings, I mean, we don't need, you're right, it's at the dismissal stage, so we
Right.
don't need to worry about sending it back. I've forgotten that. Okay, so then my next question is, if we get to that point, I don't see where, even if we would agree that this was potentially a seizure, this was a seizure, and even if we were to find a constitutional violation or assume one, as the district court did here, despite finding no seizure, tell me about the clearly established prong. What authority are you looking to where this, not only the officer, but here it would have been the paramedic
Correct.
would have had notice that his conduct under these particular facts was a constitutional violation?
Well, I think that you can look to the case with the case versus Weigel versus Broad case, where you're dealing with a person who is exhibiting those symptoms, particularly dealing that Mr. Dizmang was exhibiting, where this courts have determined that even using on a person that's in a prone position and putting pressure on their upper torso could result in death. So I think it's
Not, there's cases out there, but they're usually several minutes of either the person's in that prone position or they're not moving. This all happened, from what I could tell, within a minute or less.
that's correct, Your Honor.
And the purpose of the restraint appeared to be to help the officer, who then moved right in and handcuffed him. I mean, there wasn't a long period of time as far as I could tell. I mean, I guess I'm concerned that this is similar enough to the cases that you cited that it would have been obvious that this was a constitutional violation.
Well, I think even if it's not a case directly on point, and very seldom, and obviously you can talk about the Supreme Court Graham versus Connor, where the courts have said it's almost never a published case directly on point. And when you
Get that. I
And-
understand that.
and
I'm
we
just
look-
saying, but in this area, it's, needs to be pretty close.
Yeah, but when you're looking at,
And we also have a paramedic here, and I don't quite know how that factors in. If it was a seizure, it was a seizure, but if it was unreasonable, it was unreasonable, but
I think when you look at the context of the case, particularly in this stage, and we're talking about the officer egregious, I think when you look at facts specific, and I think you have to look at the facts when you're dealing with a use of force, particularly Fourth Amendment violation. And as I stated before, you had Officer Reed and the paramedic coming on scene and seeing a person in a position that clearly was oxygen deprived, who was hunched over, who was dealing with needed oxygen. And then subsequently, that same paramedic uses a restraint to deprive him of oxygen. I think you get beyond, to me, it's like when you have a case, if you have a person that's in a helicopter, police helicopter, and you don't have a case before and they push him out. I think the facts are so obviously egregious that you don't even need a case on point where this paramedic engaged, particularly in this conduct and act. And I think I'm running out of time.
question, and maybe,
go as- you
yeah,
go as long as you
apologize.
like.
Can't let you sit down just yet, but I have a question on your claim against the other officer, or the other individual defendant, Officer Reed.
Correct.
It seems to me that you have maybe waived or given up on your claim, which below, as I read it, was the violation of the duty to intervene, that he should have intervened when this was all going on. And that's how it was briefed, and that's how the district court decided. But then you're now here on appeal, and you're talking about a substantive due process violation, as far as I can see. There's no mention of any duty to intervene, and it seems to be a different claim that wasn't made below. What, can you explain that, or?
Well, I think that when we're talking about the obviously at the stage where you're talking about motion to dismiss and the claims are particularly made in a complaint as to whether, and I think with the district court.
Legal claim now, not the facts.
Right. I think
It seems to have morphed at the appeal stage into a 14th Amendment claim instead of a Fourth Amendment claim.
And are you particularly talking about a special relationship?
Yeah, that's what you're alleging in the appeal.
So I think within the context of that brief is that we're not waiving our intervener. We just gave another way, particularly where you're talking about an officer who have a special relationship, to the extent if this court's determined there was no seizure by the paramedic. We didn't waive that he had a duty to intervene. I think within the context of the.
Intervene under the Fourth Amendment in your appeal brief? I didn't see it.
Well, I think in the context of he had a duty to stop under the special relationship argument, I believe that's where it's embedded that he had a duty to intervene, particularly to stop him from what we believe was committing a constitutional violation. So I think within the context of that argument, there's no waiver of the duty to intervene. I think more so the title talks about special relationship, but we still within the confinements that he had a duty to intervene to stop the appellee Fisher from that we believe is using a chokehold on Mr. Dizmang. So that's kind of where we stand in our argument, particularly within the context of that special relationship argument, that he still had a duty to intervene. So we did not. I don't believe we waived it. Thank you. Other questions?
I think you cited Jones versus Hunt, and I think you were acknowledging that that's a new site. Is that right? Because I didn't see that.
Yes, Your Honor. Jones versus Hunt.
Do you mind sometime this week, we have a Rule 28J, and I should say you hadn't done anything wrong, but I was going to ask you to do me a favor. Would you file a letter? You might look at that rule, it's 28J, and you file it with the court clerk, and the only thing that I was going to ask you to put in there is the citation for Jones versus Hunt. You don't need to in fact, I'd ask you, don't make any argument. You already made it today. But that way, when we're looking for that case, we'll know where to find it.
Thank you, Your Honor. Thank you.
Okay. And unfortunately, you have been fully heard, but I think you ran out of rebuttal.
Thank you. Thanks.
Good morning, Your Honors, and may it please the Court. My name is Jonathan Eddy. I'm here on behalf of paramedic defendant Nick Fisher. With me is counsel for Officer Reed, Mr. Vaughn. He and I intend to split time equally today, so we'll have time to address issues that are specific to his client. So I'll do my best to make my arguments as efficiently as possible so Mr. Vaughn has enough time. At bottom, Your Honors, the estate has failed to overcome Nick Fisher's qualified immunity. It has not identified any clearly established law. Specifically, Mr. Daniels has not put forward a single case finding that a paramedic violates the Constitution when he's in the process of effectuating, in the process of restraining an individual for purposes of a medical transport. While this wasn't addressed today at oral argument, plaintiff relies on the Torres versus Madrid case in his briefing. Torres versus Madrid is not on point, Your Honor. It does not advance their argument. Torres versus Madrid was expressly limited to apprehensions and dealt with the application of force, in that case, the shooting of a suspect while officers were in the process of effectuating a felony arrest warrant. Torres versus Madrid also relied heavily on the Hodari D decision, which itself dealt exclusively with arrest, and specifically in that case, officers attempting to effectuate an arrest of a fleeing suspect.
Well, what if he did, to take that example, what if he did not to effect an arrest, but, we got to get this guy in a transport, he may walk in front of traffic again, and Fisher shoots him in the leg, wants to make sure he's clear, he's not hitting an artery, he's an expert marksman, shoots him in the leg to disable him so that Reed can handcuff him behind his back, get him in a transport. Is that a clearly established violation, even though he's acting in a paramedical capacity?
So are you asking if paramedic Reed shot? Oh, okay.
I'm asking if Fisher, you're representing Fisher.
Or excuse me, paramedic Fisher shot? You mentioned, I'm sorry, I think we're getting the
Yeah, I'm
individuals
saying
confused.
if your whole point is that Fisher's just trying to help Reed.
Correct.
To get this guy.
Right.
And so what if Fisher says, okay, well, I got to do something to help my buddy. I'm going to shoot him in the leg, make sure don't hit an artery, and then Reed is able to, okay, well, he's on the ground, he's bleeding from this gunshot that your client inflicted. Can we construe the allegations of the complaint to say that that is a clearly established violation of the Fourth Amendment, even if Fisher is acting in a purely paramedical capacity, not to effectuate an arrest, but to facilitate Officer Reed's ability to transport the gentleman to get help?
So that question goes to the function-dependent test, which has essentially been adopted by at least 5 other circuit courts of appeals, or at least adopted by some and acknowledged by others, stemming from the Sixth Circuit opinion in Pete. And so in that situation, essentially what you'd have to be looking at with respect to paramedic Fisher's qualified immunity is what function was he undertaking at that moment? What was he attempting to do? And there are no allegations in the complaint to suggest that paramedic Fisher had pointed a weapon or even carried a weapon because he was a paramedic.
I think that's why I called it, I'm not trying to make fun or anything, but I know that. And so I'm just trying to ask, let's say hypothetical. We'll say it's a hypothetical question. Would you say that is a clearly established violation? Ours isn't that case, and so it's different? Or would you say that would be a clearly established violation?
Well, in that situation, I think what you're looking more at is the force used by the officer to subdue the individual. That's, I think, is a separate question. That goes to objective reasonableness. The separate question is, was a seizure effectuated? And to find the answer to that question, what you need to look at is the function-dependent test. What was the function that the paramedic or the officer were attempting to achieve?
Let's say the function is exactly the function that you were attributing to Fisher in this case. The function was not to effectuate a seizure or an arrest. It was to facilitate your co-defendant's ability to handcuff the gentleman behind his back, to transport him to get help in a purely paramedical capacity. That was his function. Was that a clearly established violation of the Fourth Amendment?
It would not be, Your Honor, based on the totality of the decisions from the 5th, 6th, 7th, 8th, and 9th Circuit Courts of Appeals that have looked specifically at these similar circumstances when paramedics are involved, sometimes in cooperation with officers and sometimes not.
If he says, you know, he's gonna kill somebody, I'm an expert marksman, Mr. Fisher says, I'm gonna shoot him in the heart, I'm gonna try to kill him, he kills him. He's not trying to effectuate an arrest. What he's really trying is to remove the guy out of harm's way so that he doesn't hit a pedestrian or hit a car. Now, can a reasonable fact finder view that as a violation of a clearly established right under the Fourth Amendment?
Well,
Seems like you're staking out an extraordinary position, and I'm just trying to make sure if you're saying that it doesn't matter what Fisher does, if he's trying to tackle him, if he's trying to inflict blood, if he's trying to kill him, it doesn't matter as long as he's saying, I'm a paramedic, I can do whatever the heck I want, I can kill a guy because I'm doing it as a paramedic. I'm not doing it as a law enforcement officer, and that can never be a clearly established violation because we have never had a precedent with such a remarkable position. Nobody's ever argued that. And so, of course, we're never going to have a precedent saying such an extraordinary, reflecting such an extraordinary position. How in the world could we say that it's not a clearly established violation to shoot a guy in order to put handcuffs behind his back when he's standing in the tree line? He's not even near this very seldom traveled road. I mean, wow.
So, Judge, I apologize. I may have misunderstood your hypothetical. I thought that you meant that Officer Reed, the law enforcement officer, shot the individual to subdue him, and then paramedic Fisher. Okay, all right. So I will concede, Your Honor, if
I'm interrogating you.
Okay. All right. So I will concede your
client. I'm saying, all Reed is doing, I don't think anybody questions, he's trying to handcuff the guy behind his back.
Correct.
It's your client that goes and decides to do a tackle that would probably, trigger a 15-yard personal foul if it was a football game. So, but I'm talking about your client, and I'm not talking about Reed. Reed's just trying to handcuff the guy.
Okay.
It's your client that I'm saying tries to shoot the guy in the leg to avoid an artery, and now you're saying that's not a clearly established violation, probably not even a violation. So I'm not saying, okay, well, let's take it one step further. Let's just say Mr. Fisher, kills the guy because, God forbid, he could walk into traffic and, hurt a pedestrian or another driver. Would that constitute a clearly established violation?
I concede, Your Honor, that if paramedic Fisher, as a paramedic, used a firearm to shoot someone who was fleeing for the purpose of providing medical treatment, that potentially that would be a clearly egregious example that could overcome qualified immunity. I concede that.
And so now, how do we write an opinion saying, okay, well, if you shoot a guy to avoid an artery, that's one thing. But if you tackle someone above the waist, causing the guy to fall back and then stay on him, when he is, according to the allegations that we have to credit, saying, I can't breathe, how then do we draw a line between that above the waist tackle, staying on the guy so that Reed can then handcuff the gentleman? How do we draw a line saying, that's not a clearly established violation, but if he shot a guy in the artery, that would be a clearly established violation? We don't have cases on either point, but I think you're acknowledging that nobody would think that was constitutional to shoot a guy. Well, why isn't it the same effect if you say you're tackling a guy above the waist and then staying on him after he's saying that I can't breathe?
Well, in this case, Your Honor, you don't need to engage in that extreme line drawing for purposes of paramedic Fisher's qualified immunity. You need only look at the other circuit court opinions that have dealt with this specific issue, two of which have specifically dealt with positional asphyxia, effectuated by either a paramedic, an officer, or a combination of both. The Pete decision dealt with those same exact facts. The most recent decision from the Ninth Circuit from 2024, the Perez decision, which is in the briefing, dealt also with positional asphyxia through a combination of restraint that was employed by the paramedic and the officers who were on scene. And the Ninth Circuit said, look, no clearly established violation here by these individuals because there's no clearly established seizure because it's clear that the officers and paramedic were there to transport this guy for medical purposes, not to place him under
Of course,
arrest.
that's not clear here, at least not from at this stage of the litigation. We've got some pretty objective-looking facts asserted here, including the officer's own statements about what he was doing and why he was doing it, that would indicate his intent was to restrain. And that's what makes it a seizure. It doesn't have to be, he doesn't have to be a law enforcement officer. His intent must be to restrain, not an intent to even restrain to provide medical care. Simply an intent to restrain is a seizure. And there is case law supporting that. And we do have objective facts here suggesting he literally was all about helping the officer who's chasing after this guy, and he says he tackled him. He says he didn't know what he was supposed to do. He'd never done anything like this before. This is the first time he'd taken anybody down. He lost him between a grove of trees. You know, there's more. But, I mean, we've got this guy's own statements. I don't know why at this stage, I understand that you could develop in discovery something more, that he was taking him down to provide him with medical care, although it doesn't appear there's any reason to provide him with medical care right now. And he even talked about, oh, I need to provide him with care, and then watched him not breathe and didn't provide him with care for 10 minutes. So you've got enough facts to get past a motion to dismiss on the seizure. And I guess I don't understand how Torres supports you. There wasn't an arrest in that case, and they did talk about an arrest, but the court there extended, applied and extended the common law rule, which doesn't require an arrest for seizure. You don't have to have an arrest. You don't even have to have necessarily an intent to arrest. It's about restraining their liberty and whether the intent of the individual, not just whether they're a law enforcement officer or not, is to restrain. And that's probably a fact question here, isn't it?
Well, respectfully, Your Honor, Torres versus Madrid was expressly limited to apprehensions. The opinion made that expressly clear. There has been no...
All about the common law, and they adopted and extended, approved and extended the common law, which does not require generally an arrest. No question in that case, they talked about it. There was no formal arrest in that case, but the point being, it's not required. And just accepting that, I'm not sure how we can, at this point, judge what this individual's intent was, particularly where we have more than we normally would have, which is even some statements from him about what happened.
Quickly, Your Honor, with respect to the statements, what's key with respect to an arrest is you always look at it from an objective standard. So whether Paramedic Reed believed that, Paramedic Fisher rather, believed that Officer Reed was attempting to effective an arrest is irrelevant.
But what
What's
about the
relevant is-
circumstances? That's a good point. That's a good point. What about the circumstances here where, he's chasing after this guy and jumping on him and hanging on to him in order for the officer to handcuff him?
Correct, so that he could be medically transported. And the allegations in the complaint actually clarify and specify what the purpose of the crisis response team was. It was there to provide emergency treatment and counseling.
Well, they didn't know till they got there what treatment was needed.
Correct, but there's a reason why a crisis response team was called to the situation and not just, a SWAT team or a group of officers for
That's
purposes
the reason that they go there.
Right.
You're saying it doesn't make any difference then what actually, happens or what their intent might be at that moment. We can assume that because it was this crisis response team that they were eventually going to transport this person for...
No, we don't have to, sorry, Your Honor. You don't have to assume anything. The allegations of the complaint do not indicate that they were there to arrest Mr. Dizmang. That allegation is
That can
completely
certainly,
conclusory.
if someone does something during the course of this whatever you want to call it, it's not an investigation, but occurring the course of this encounter, certainly it could change to an arrest situation. And this person was, he was running around in traffic and they were trying to grab him and they were running around and back and forth and he went back out. And to me, it's probably more at this point, more about safety restraining him for his own safety, as well as perhaps, people out there driving their cars on the street. And maybe that's what it was, but it's not necessarily at that point to administer medical care.
Well, it was a combination of issues. Safety for the public, certainly Mr. Dizmang's well-being, which was the whole reason they were there trying to restrain him so that he could be transported to the hospital for treatment.
Well, I'm saying at that very moment that the restraint occurs, and under the setting that it occurred, not necessarily what they might have intended to find, or what they thought they were going to find, or what they thought they were going to do, but what happened in that setting, there may be a question of fact as to what the intent was.
Right, but at the end of the day, it ultimately comes down to, was there a clearly established seizure? And if
Right,
there was,
that's
was
the
there a
next question.
was there a
Right.
clearly established violation here by either paramedic Fisher or Officer Reed? And our position, as outlined in the brief, is that there definitely was not.
Thank you.
Any other questions?
Thank you. All your time's exhausted, but we're going to give you 1 minute.
Thank you, Your Honors.
And
I can't say I wasn't warned, Your Honor. Your Honor, I'm going to be very brief. I'm going to go directly to Judge Moritz' question with regard to abandonment.
Yeah.
If you look at the actual opening brief, the intervene is mentioned twice, 2 times. One in the jurisdictional statement, and second, just in talking about what some of the claims were. Otherwise, there is absolutely no direction to that argument. We did make the argument that it was waived as well, I believe on page 26 of the brief. And there's a footnote with some cases
Yeah.
cited. So we do believe that it has been waived. Even if you don't, then I think
It has changed, though. It has morphed into a 14th Amendment claim,
which was not included in the
not
complaint.
pleaded in the complaint.
And we
Okay.
also cite cases that you can't bring it up now, and there's some 10th Circuit authority on that. I would use the last 6 seconds that I have to emphasize the second prong of qualified immunity. And there's 4, Judge Sweeney emphasized the second prong, which requires that there be an observation of the officer of another officer's use of excessive force, which is not a paramedic. And there is a long line of cases which emphasizes that specific second provision in the elements. And we would have to substantively change the elements of the, I said excessive force, of the failure to intervene to be able to fit this case, this round case, into a square peg that plaintiff is trying to force it in. I would otherwise stand on my briefs for the remainder of my argument.
Good. Okay, thank you very much. This matter will be submitted. Thank you both, all 3 counsel. As the previous case, I thought the briefing and the advocacy was excellent. We really appreciate it. Matter submitted. We'll hear the next. Do you want to keep going? The third case that we'll hear this morning is a case called Chaussee versus Auto Owners, 251120. And we'll hear from counsel whenever you're ready. Okay, we'll hear from Mr. Irving whenever you're ready.
May it please the court, my name is Gideon Irving. I'm appearing on behalf of the plaintiff appellants. Our clients were added as defendants in the underlying litigation by way of the second amended complaint. For auto owners to be able to avoid its duty to defend against that complaint It needed to prove that there was no arguable, plausible, or even doubtful way that the factual allegations alleged against our clients could be construed as property damage caused by an occurrence as defined in the policy. And I'm going to start with the occurrence issue. Colorado law recognizes that volitional acts that result in damage that is unintended, unforeseen, or unexpected can fall within the policy's definition of occurrence. And when we look at the factual allegations alleged against our 3 clients as distinct from the 7 other defendants in the underlying case, it's unclear what our clients are alleged to have actually done. It's unclear that our clients, or I should say rather, it's unalleged that our clients actually knew about Van Sant, knew Van Sant was attempting to operate an RV park, and it's absolutely not alleged that our clients intended to prevent Van Sant from doing so. And that's well within the policy's definition of
I'm
occurrence.
confused about that, I guess. It seemed like that's the only thing they alleged. I mean, they're part of a group. I get that it's a confusing, this underlying case in state court, very confusing. But there isn't any question that they've grouped they've grouped them in, your clients, with all these other folks that they've sued as defendants in this kind of nebulous claim. But no question, they're alleging intentional acts by all of these defendants. And your clients may have been a little confused about the complaint, and I don't blame them, but I don't understand how you can suggest that they weren't accusing your clients of intentional action.
Your Honor, I'll start first with the applicable legal standard, which is that the facts of the complaint and not the stylization or the legal claims are what controls the inquiry on the duty to defend. Okay, so we have...
Right, I understand,
so
but
we-
you gotta look at, you gotta look at the allegations.
Right, and I'd like to do that. So as to the factual allegations, and Your Honor, I don't want to belabor it because I know you understand it, but there are places where it's alleged that the town defendants did something which does not include our clients. And then there's the same allegation, and I'm speaking directly to the passage of these ordinances. One place says the town defendants passed them. One place says that our defendants, as part of a group of Chaussee defendants, passed them. And then there's other particular allegations that say specifically Brent, Tyler, Cameron Chaussee were involved in it. And
A lot of confusion.
Right, and so-
A lot of lack of specificity, I would call it.
exactly, and Your Honor,
But that doesn't change the essential nature of the complaint,
well, it
or
does.
the petition.
Right, and so, Your Honor, the point is that it's not that there is a conspiracy claim, but again, looking at those factual allegations I was just talking about, when our clients are vaguely and ambiguously included somewhere and excluded elsewhere, that is where, under the Colorado legal test, there is some doubt that arises as to the level of our client's culpability. And on that point, I'll direct this court to its own decision. It's unpublished, but it's the KF 103 case that was cited in our briefs. And as to one of the claims that the court analyzed there, it specifically explained how there was some allegation of intentional conduct, there was some allegation of unintentional conduct, and that just because intentional allegations were interspersed with unintentional conduct is not enough to remove this.
What allegation was there in this kind of confusing complaint of unintentional conduct? I get that there was unclear allegations about a lot of things, but certainly there was nothing that I could see alleged about anybody other than intentional conduct.
Right.
So that, I see this as distinct from that case, where you have a mix of both kinds of conduct alleged.
And Your Honor, your question somewhat implicates the question about who bears the burden here, because it's the insurance company's burden to prove that the allegations are completely outside of any plausible reading that they could be an occurrence, could even doubtfully be an occurrence.
Nevertheless, could you answer for me what you think
Yes, and
the
so.
allegations were that alleged unintentional conduct?
Right, and so again, we have to take into account this ambiguity. The specific allegations as to our 3 clients are that they were the grandparents of certain other family members, that they were property or business owners. And what I'd like to do to direct the court to a particular allegation that I think kind of sums it up and explains it, it's section 77, and it's a subparagraph B in that underlying complaint, where it says that our clients, by exerting their power and influence, ensured that the 2016 and 2018 ordinances were passed. And so that is, again, at most, a general intent alleged to our clients, but it does not rise to that specific intent to cause an injury by preventing Van Sant from operating an RV park.
So just want to make sure that I understand that last part of your answer to my colleague's question. So when you were asked to identify an allegation that suggests that their liability was predicated on unintentional conduct, we can refer to paragraph 77B, and that is, other than allegations about parental relationships, which I don't think it's fair to say that those are unintentional conduct. I mean, it is unintentional who your family is. But the only thing that you can put your finger on is 77B?
Well, Your Honor, I can expand on that. So I point to 77B because, to me, when you look at the factual allegations as a whole and recognizing where they're inconsistent and unclear and vague, that, to me, sums up what this complaint is trying to say.
Well, the reason I'm asking you that is 77B is obviously preceded by the introductory clause. Defendants have variously engaged in overt acts in furtherance of that combination or conspiracy. Paragraph 75 that introduces paragraph 77B uses verbs involving deliberate conduct, in fact, including the verb deliberately. Defendants have knowingly, by deliberately participating in a shared commitment to a common scheme. How can you engage in a common scheme or a conspiracy? Or, to take your paragraph, how can you engage in overt facts in furtherance of a combination or conspiracy by accident? Or you use the first 30 seconds of your argument, and when you don't foresee something, you don't subject it. How can you engage in a combination or conspiracy under the allegation you're hanging your head on to say, well, we didn't foresee that?
So the answer really to your question, Your Honor, is that it's the factual allegations and not the fact that a conspiracy claim was brought against our clients that determine the question of the duty to defend.
But
and
you
so
answered her question based on an allegation, not in the background section involving the historical facts, but you're saying, let's look at 77, ignore the prelude, combination or conspiracy, ignore 75. What I want you, three judges, to rely on are the background facts that don't say anything about any basis for liability, whether it's deliberate or accidental. All it identifies is parental relationships, sibling relationships, grandparental relationships. And those family relationships don't provide a factual predicate for liability, whether it's deliberate or accidental.
and Your Honor, that's where I'll disagree with you.
Okay.
Because we don't know precisely, when you're talking about the overt acts that our clients are alleged to have taken in furtherance of a conspiracy, we cannot figure out what those overt acts supposedly are. There are not factual allegations.
And you're talking about lack of specifics here, but that's totally different than saying that this somehow asserts an unintended, act.
Well, and Your Honor,
And that, even the paragraph you point to, that these defendants exerted power over the town to ensure that the events were enacted, that certainly doesn't suggest unintended consequences to me. I mean, it sounds like they exerted their power in order to ensure that something else happened. I mean, that's not, I just don't see reading the allegation exactly the opposite.
and perhaps it would shake out that way when the duty to indemnify was later decided, but here on the duty to defend question, there is some doubt about that. And Your Honor, I can put some more meat on the bones of this. And so Just conceptually, it's unclear what our clients are alleged to have actually done, but they are alleged to have done something. And at most, our clients are alleged to have ensured the passage of these amendments, but there are not allegations that show that our clients specifically intended to prevent Van Sant from operating the RV park. Maybe that's how they shake out in the end, but it is at least doubtful at this stage whether or not the allegations specifically allege that type of specific intent. And, Your Honors, I would like to kind of paint this conceptual
Are you sure
approach.
about that? Isn't there an allegation in the complaint that the Chaussees, quote, illegally contracted, combined, or conspired, and will continue to do so to restrain trade in a relevant market consisting of the long-term rental of RV parking spaces by RV parks?
Yes, Your Honor, and 2 points about that. First is, that's another general allegation against a group of defendants where it's unclear how our clients actually may have been involved in that. But the second point is that those allegations of those natures that say that our clients participated in a conspiracy and knowingly did these things, those are legal conclusions that are devoid of any actual factual specificity or elaboration as to our clients. And district courts regularly exclude those types of allegations when they're reviewing the sufficiency of a
Except do they when
complaint.
they're applying Colorado law, when they compare the four corners of the complaint to the terms of the contract, the insurance contract?
They do, Your Honor. Colorado cannot be more clear that it's the factual allegations and not the legal claims. And I might add to your kind of question there, Your Honor, is that the court's required to view the factual allegations in the way that is most likely to result in possible coverage for our clients. And so that includes looking at some specific factual allegations on their own or viewing the complaint in toto. And that is well established in the case law, but especially in the Hecla mining case. And if the court wants a little more elucidation on that, footnote 8 in the Hecla case specifically talks about viewing allegations in toto if there is some doubt, and the text of the opinion itself says if there are any facts that could plausibly be construed as falling within the coverage of the policy, then the duty to defend is triggered. Unless the court has further questions right now, I'd like to reserve the remainder of my time.
Okay. Thank you.
Good morning, Your Honors. My name is Aaron Bell, and may it please the court, I represent the defendant, Appellee Auto Owners Insurance. The policy at issue here requires both that the damage be property damage and that that property damage be caused by an accident. If either of those is missing, there's no coverage, and the district court's order should be upheld. In this case, in the underlying suit, the only claims against these appellants were Sherman Act conspiracy claims. And likewise, the factual allegations in the complaint were of a conspiracy and an intentional conduct, not of an accident. So insurance is not designed to cover an insurer's intentional acts, like conspiracy. There's no way to reasonably price the risks that an insured will engage in intentional wrongful conduct. I think that as the Seventh Circuit noted in the Curtis Universal case, insurance companies will not insure against liability for antitrust violations, a liability based on deliberate rather than inadvertent actions. The policy here requires that there be an occurrence, and the policy then specifically defines occurrence as an accident. The allegations in the complaint, and Your Honors, I think, brought this out already, so I won't belabor it, but the allegations over and over again in this complaint are of intentional, deliberate conduct, and there simply are no allegations of accidental conduct. Now, the plaintiff appellant makes the argument that the pleadings are unclear. that the pleadings are threadbare. Well, threadbare allegations of a conspiracy are threadbare allegations of a conspiracy. They don't transform into allegations of an accident. And there just are no such allegations. And I think it was very notable that when specifically asked to provide an example, the example provided was contextually very clearly of intentional conduct. As Your Honor noted, paragraph 77 is immediately preceded by paragraph 75, which uses words like intentional and deliberate and conspiracy.
Can I ask you a hypothetical question? What if the plaintiff, during the pendency of the proceeding in district court, said, we want to amend the complaint. We want to limit the antitrust allegations to the Chaussee relatives who were in municipal government, and that the plaintiffs in this case who are seeking a reimbursement for their defense costs, we, the plaintiffs, are not alleging that they knew about this conspiracy. The conspiracy was on the part of their relatives, their kids, but that they were beneficiaries of this conspiracy. In other words, the town defendants conspired to promote the business interests of their relatives, the plaintiffs in this case. And then the district court says, well, this seems to be maybe you're bringing up, this is an entirely different lawsuit than the one you had pleaded earlier. And the reply from the plaintiff is, well, tell us what is inconsistent with that, between that and the complaint that we're here on. It's entirely consistent. Wouldn't that complaint have triggered an arguable duty to defend, because that would be an accidental benefit to the Chaussee defendants in the Van Sant litigation, where there was no allegation of a conspiracy on their part. They were the beneficiaries of the conspiracy by their relatives.
Well, I think in that hypothetical, which is, of course, very different than what was pleaded in this case, there still needs to be an occurrence. So in that hypothetical amended complaint, there's really no allegation that these Chaussee appellants did anything at all.
Well, that's exactly the point in the hypothetical. In other words, if you accept that an occurrence or an accident has to be not subjectively foreseen, and not have been the part of deliberate conduct, under my hypothetical, the Chaussee defendants, the plaintiffs in this case, did not do anything wrong, but it would be, let's say, an equitable claim for unjust enrichment. They were unjustly enriched because they were the beneficiaries of a violation of the Sherman Act perpetrated by their relatives. The relatives who participated in the conspiracy solely to benefit fortuitously on these particular plaintiffs. And so there would be no deliberate conduct. There would be no actual foresight of what their, the black sheeps and their families, their relatives had done, but they would be the beneficiaries and potentially subject to liability an unjust enrichment theory, all of which arguably would trigger a duty to defend, or would it?
Well, I think to have the duty to defend, or to have coverage at all, what is needed is an occurrence. And in this case, given that in this hypothetical amended complaint, these Chaussee appellants did nothing whatsoever, I don't think there's an occurrence there. They didn't,
because it was an accidental benefit that was bestowed on them by virtue of their relatives.
but in that hypothetical, there's no allegation that they did anything accidentally either.
There's no allegation of an act in this hypothetical.
Correct. In that hypothetical, they just did nothing whatsoever, which of course is very different than what was alleged here. I just briefly, if I may, like to address the unjust enrichment, because that's something that the plaintiffs brought up in their reply brief, and we didn't have a chance to address in our briefing. And they suggest that this case could somehow be construed as an unjust enrichment case. Obviously, it wasn't an unjust enrichment case. It was very explicitly a conspiracy case. But in addition, unjust enrichment is a quasi-contractual theory of recovery. And there's just no relationship whatsoever between these Chaussee appellants and Van Sant, well, except that they intentionally conspired against Van Sant, which is certainly not accidental. And furthermore, unjust enrichment requires that that there be a conveyance of a benefit. And there was no conveyance of a benefit by Van Sant to the Chaussees. The only thing that happened allegedly in the underlying complaint was that the Chaussees conspired to enact these ordinances in order to restrain trade, and then that ended up harming Van Sant. There's no conveyance such that it would be inequitable for the Chaussees to retain it without paying fair value for it. And another point that was brought up is that we need to look at the allegations in the complaint as a whole, and I completely agree with that. I think that's exactly right. And I think in this case, what the allegations in the complaint as a whole show over and over again is that this is about intentional conduct. And it's not about an accident or an occurrence, which are synonymous in the policy.
So following up on the unjust enrichment hypothetical that my colleague put to you, let me ask, what do you think is the state of Colorado law on the duty to defend where there's some plausible potential amendment to a complaint that might implicate the policy? And what authority would you cite for what the state of the law is? Does the duty to defend not become implicated until an amendment's filed and the claim's asserted and new facts are alleged, or?
Correct. I think an insurer has an ongoing duty to evaluate the claims that are being made against its insureds. So if a complaint is filed and it alleges conspiracy, Sherman Act violations, as in this case, that may not be covered. If in some hypothetical, there's an amended complaint and now it alleges common law negligence, the insurer has an ongoing duty to evaluate those new allegations, and if those new allegations changes the coverage position, then the insurer has a responsibility to act accordingly, which in that case might well mean providing a defense. I think that the duty to defend, while broad, is not completely open-ended and unlimited, such that an insurer has to defend against claims for clearly intentional conduct because of the hypothetical possibility that at some point in the future, additional claims for accidental negligent conduct might be added. At that point, there's simply no limitations on the duty to defend whatsoever. One other point, if I may, in the time that's remaining. So one thing I was struck by is that there were complaints here about the non-specificity of the underlying complaint and how we should understand it to have been insufficient. And perhaps that's true. But I think it's worth noting that the reason these Chaussee appellants prevailed in the underlying action wasn't because of lack of specificity of the complaint. It was because of the Noor-Pennington Doctrine. And the Noor-Pennington Doctrine is a creature of the First Amendment. There's a First Amendment right to petition the government, and thus that doctrine states that there can't be antitrust liability for petitioning activity. And that's how these appellants prevailed below, based on a doctrine that is specific to the antitrust conduct or context. And that doctrine has no relevance in the context of accidental, negligent conduct. So effectively, what these Chaussee appellants are arguing here is that they were sued under Sherman Act claims. They asserted a defense that arises only in the context of Sherman Act claims. They prevailed on that defense. They prevailed again on that defense on appeal. But now they want to argue that the underlying complaint was really about accidental conduct. And that's not a change in position that we think should be entertained.
Well, Colorado law doesn't invite us to consider potential defenses that may be asserted when evaluating whether the policy, the duty to defend, is implicated by the allegations in the complaint. Do you agree with that?
I'm sorry, Your Honor, could you say that again?
I mean, I think Colorado law seems pretty clear. We look at the complaint, we look at the allegations, we look at the coverage, we look at the contract. And I think I think pregnant in your argument, at least, is the idea that we also consider potential affirmative defenses, or maybe, I guess what I mean to say is, I understand your argument to say potential defenses an insured may assert in an underlying claim are also relevant in deciding the duty to defend, but there's no case law for that, is
No,
there?
I'm sorry if that was unclear, Your Honor. My point isn't about affirmative defenses further informing the duty to defend argument. Although, in this case, I think the allegations in the complaint are pretty crystal clear. My point is that—
It's an estoppel argument?
Correct, Your Honor. My point is that it's a naked change in position that these Chaussee appellants made and prevailed on. An argument in the underlying case is predicated entirely on this case being about antitrust liability. And now we're arguing that really substantively, if you ignore almost everything that's in the complaint, that this case really is about accidental conduct. And that's what we think is wrong and should not be entertained. And unless Your Honors have any further questions, I will respectfully request that the district court's order be upheld.
No, thank you.
All right, thank you.
As you're on your way to the podium, to save you some time, let me pose the follow-up question to the last exchange you and I had. You talked about Colorado law inviting us judges, considering the duty to defend, to strip out of complaints conclusory allegations, and I suppose it comes back to the point that my colleagues were stressing earlier. I don't understand how your argument gets any stronger. The more paragraphs we strip out of the underlying complaint, assuming your point that they're conclusory. That still doesn't get us any closer to an allegation about accidental conduct or for unforeseen consequences, does it?
Your Honor, it does actually, because the actual, if you go look at these very sparse, specific allegations of fact against our clients, they are alleged to have done something. And the ambiguity as to what they actually did is precisely what's contemplated by the duty to defend and the complaint rule. This is the Colorado public policy articulated by the Supreme Court in HECLA, which is that the insureds have an expectation of defense. And that risk that maybe eventually the duty to indemnify does not appear, that's shifted to the insurer, who is supposed to assume the defense and actually allow, going to the exchange that we just had, allow our clients to assert defenses like the Noor-Pennington Doctrine, et cetera. On the complaint as pleaded, the Noor-Pennington Doctrine and any sort of defenses are not implicated. And so, Your Honor, again, we have to look at the allegations in a way as whether there's doubtful, plausible, possible, factual allegations that could be construed as our clients doing an act in which they didn't intend to restrain Van Sant from operating an RV park, and that resulted in property damage. And as it goes to that question on whether this really was accidental, whether they intended these restraints of trade that they were alleged to have intended, also speaking to the underlying litigation, it was resolved by a published decision of this court, which I would invite the judges to look at. And it found that there was an innocent explanation for passing these amendments, and that was the desire to keep the town clean. And I will stop there unless the court would allow me more time or has any further questions.
Okay, thank you very much. I also want to thank both counsel for your excellent briefing and your excellent advocacy today. It's greatly appreciated. This matter will be submitted. We'll take, why don't we take a 10-minute break? Come get us in 10 minutes so we don't fall asleep back there.
Court's in recess for 10 minutes.
Unless we did 20 years ago. Douglas County Infection Control. Yes. Like I'm looking. I didn't remember. Yeah. I didn't remember it until I was mentioned. Yeah. That's right. Good to see you again. I don't like being on the other side. I know. Well, we need to go to the same side. Digital screen. That's right. Yeah. We do. That's all. Good. Figure it out. Good to see you. Good to see you. But if there's a comment, just pass it forward. Yep. That's what we're concerned about.
Judges of the United States Court of Appeals for the 10th Circuit.
All right, please have a seat.
Not at all, thank you.
So we have two more cases to hear this morning. The first is Ascent versus Ascent Classical Academy. This is 25-1132, and we'll be delighted to hear from Mr. Drexler.
Thank you, Your Honor. My name is Scott Drexler. I represent the Appellant Ascent Classical Academy, to whom I shall refer to as Ascent in my argument. This case is primarily a case of contract interpretation. And the relief we're asking is that this court reverse the lower court's contractual interpretation, provide the correct interpretation, and then remand for factual findings to determine what, if any, and the extent of trademark infringement, intellectual property infringement exists. So that's what we're asking. In the contract here, basically the way it was structured is Ascent kept all of the current and future intellectual property except for one limited carve-out. So there were 4 contracts, each of which was identical. And in each one of those contracts, the charter schools, ACACS, retained the right to use a trade name, Ascent Classical Academy of Douglas County in the first contract, and then, of course, different specific trade names in the 3 subsequent contracts. And a trade name is a specific name for a specific school. And that's what ACACS was able to retain and nothing else. The court, of course, rejected this approach and committed 4 errors in its analysis. And let me treat each one individually. First, when you look at the court's analysis, the court had an improper reading of the word, the legalistic pronoun, the same. So basically, the language itself says, however, the name Ascent Classical Academy of Douglas County shall be a trade name of the school, and the school shall have the right to use the same. So the question is, what does the same refer to? Well, the court said the same refers to name, and that's just frankly incorrect. Under common interpretation, last antecedent, the same refers as a pronoun, legalistic pronoun. It refers to the most recent item in a list, and that most recent item was the last one, trade name. So when it says Ascent Classical, when it says the right to use the same refers to the trade name. And of course, a trade name under the Lanham Act is clearly defined as a specific name for a specific school. And we cite, modern English usage and textual analysis, Garner and Scalia, which I believe the appellee has cited as well. We both like, apparently, that source. So that was the first error. The second error is that the court said, well, when you look at the name of a school, that's much different than trade name. And in fact, structurally, that sentence, the name, is equal to the Ascent Classical Academy of Douglas County, which is equal to the trade name. Logically, that is the analysis. So if you break down or outline the sentence, you would say, the name shall be a trade name. As a lawyer, sometimes I like to use the word, shall comprise or shall be constituted. It makes me sound a little more educated. But shall be is about as direct as it gets. The name shall be a trade name. So name and trade name are one and the same.
The fact that the parties chose to employ the word a trade name instead of the trade name.
I think it's in this instance, whether it's the definitive or indefinitive use, it's irrelevant.
Doesn't A suggest, as opposed to the, that there are several?
There very well may be.
And this is one.
There very well may be. The ACACS may say, we want to also get a trade name called Rocky Mountain Academy, something different. And that doesn't involve Ascent. It doesn't involve Ascent's intellectual property. What does involve Ascent's intellectual property is Ascent Classical Academy of Douglas County. And that is what is being conveyed here, shall be a trade name. Whether it's the trade name, in other words, whether ACHS only has that as a trade name, or whether they have other trade names, is irrelevant for this contractual interpretation.
I don't think you're asking us to say, with respect to the error that you claim on the phrase "the same," I think what you are saying today is that it's at least ambiguous. You're not asking us, or are you telling us that as a matter of contract interpretation, "the same" here means something different than Judge Gallagher said?
I'm saying it means something different, absolutely.
Matter of law.
As a matter of law, as a matter of contractual interpretation. The same refers to trade name. It is the last antecedent. If you look at Garner, and the same has a long pedigree. I know it's been treated poorly by many commentators, but it's been used since the 14th century. Shakespeare used it in Comedy of Errors, and as Garner noted, it's used in Article 2 of the Constitution for succession of vice presidents when a president is unable to exercise various powers of the office, and it is the same. The same refers to office. And that's the way it is commonly and consistently, and I would say almost uniformly interpreted. But I would also add that even if it were to refer to name, name shall be a trade name. Name is Ascent Classical Academy of Douglas County. They're all one and the same. The name is a very specific defined term using quotation marks, which is a trade name, or shall be is the phrase they use. So we don't have to rely entirely upon the last antecedent principle for determining what the legalistic pronoun the same refers to. But that in and of itself is sufficient. Yes, ma'am.
Can I follow up on that question? This was a dismissal, right? And the
Yes.
basis of the motion to dismiss was the interpretation, trying to think,
Of the
was
word use.
interpretation of, the interpretation of this particular paragraph K, and,
Are, but yes, ma'am.
or whatever it is, R. But I mean, don't we just have to say, well, we disagree with the interpretation and the district court erred in dismissing it? Why would we need to actually interpret it at this point?
Because
Judgment question, wouldn't you file cross motions for summary judgment at some point?
I don't think
You
so.
haven't asked for judgment at this point.
No.
You're basically asking us for judgment, aren't you, if we interpret the contract in the fashion that you would like?
This is an important factor, but I don't think it resolves everything, because what we're really asking for is,
Do we need to say, can we say the district court erred in interpreting a contract in this manner
yes,
and remand? Either way, we're going to remand, I presume, is what you're
I hope.
asking for. I'm just saying.
Yes.
You seem to be asking us for more, which is an interpretation in your favor that obviously you haven't asked for yet.
We are asking for that, and this court is, and contractual interpretation is a matter of law, and so, well, Your Honor, I guess our point is contractual interpretation is a matter of law. That's something for the courts to do.
Normally doesn't come at a motion to dismiss stage. Usually you have cross motions for summary judgment on a contract interpretation.
We'd like to get as much as we can out of you, Your Honor, so to the extent you're willing to,
Shelby's question was really rather well taken, and I was interested in the response,
we think that the meaning of that contractual term is clear and that this court is equipped to be able to make that decision based on the language of the contract itself at this point and to reverse the court's interpretation. Not merely say, well, it's not what the lower court said, but it could be something else.
I think a necessary implication of that is you contend that this language that's in dispute in the contract is unambiguous.
That is correct. Nor did the court did not make an ambiguity finding. So that's one area where we would likely agree with the court that it is not ambiguous.
We agree. I don't think there's a dispute. The parties don't dispute the state of Colorado law on the question. When we're construing the contract, we consider the subject matter of the contract, the object of making the contract, the sense in which the parties stood the language at the time the contract was made, the purposes and objects, all of that, right?
Correct.
So I know that you're in a structure of the 4 errors, and I'm going to pull you right out of that, but when we look at the rest of the contract, so the subject matter of the contract, the object, and the like, isn't your construction in tension with the rest of the contract?
Not at all.
What about the property rights provision in the contract, for example? Like, what sense does it make to say that the teaching materials, the physical property, the other items that the school has, all of which may bear any number of marks that may be different from the part in quotations in paragraph in R, does the school get to keep it and they just can't use the equipment if it's marked with, say, initials?
It would likely require some form of rebranding, but it's very clear with respect to intellectual property. I mean, it states intellectual property, and the relevant section of Section 3R, which is a pretty long section, it includes the phrase, "No other use of Ascent trademarks is permitted without Ascent prior written permission. The school shall acquire no rights. All goodwill of Ascent trademarks shall inure to the benefit."
And stronger on intellectual property for sure.
And
which
that's
is
what we're
why-
talking about
Which is
here.
why I want to focus you on the physical property. The contract seems to grant something that you maintain, your interpretation of the contract would take away. I think it would likely read out of the contract the provision that says, keep all the T-shirts and the gym equipment and the chairs that are marked with the initials instead of the full written name, the whole name in contract, 7 words. Anything that you have that isn't marked in 7 words, you need to rebrand or destroy. And if you can't rebrand it, you destroy it. Otherwise, it's a trademark violation. So what's the purpose of that provision in the contract if the parties mutually understood and intended that you couldn't use any of it?
Well, we would disagree that the two are inextricably bound, that one can separate physical property with intellectual property.
Well, there's
But I would
different-
also point out, if I may, just real quick, that's not a proper form of analysis at this point for a motion to dismiss. We're looking at the specific contractual term, not the consequences of what would happen if in fact trademark infringements are found.
No, it's a reading in the context of the subject matter of the contract in its totality. And I think contract law would tell us to consider other provisions in the contract and not to adopt a construction that would write part of the contract out. Is that true?
As a general proposition, I'll accept that, but the totality in this instance is particularly weak. I would submit that those arguments that you're positing are particularly weak in light of very clear and explicit language that talks about all of the IP is kept by Ascent except for a very specific limited carve-out.
As the argument, but I'm going to jump to your 4th point. I think the 4th point of error you're going to tell us is when Judge Gallagher considered common usage among high schools and other schools throughout the country or other institutions and organizations, and you say it's error, he considered facts outside the record, but
Yes.
How do you consider a judge's common sense under Rule 12, but also the subject matter, the object of the contract and the like, if you just say a judge can't take notice of things in the world when evaluating what it makes sense in the context of the party's language?
Technically, that's my 3rd point, but I appreciate it. If I may answer, I know my time is short, very quickly. As my children tell me all the time, my hair is gray and I'm old and we live in a different world. The judge, I think, looked at an outmoded analysis. He says, look, this is how schools always work. And he said the law of candy bars is different than the law of schools, which has no support in the record. But he says, and he uses the word customarily, he says, schools customarily identify themselves. Under black letter law in Colorado, that type of customary usage is a factual matter, not subject to the judge's whims. But I would also say this, the judge's mode, probably as mine is somewhat outdated. We may have grown up, I think the judge is around my age, in a world, for example, in Denver, where you had North High School, South High School, East High School, West High School. But that's not the world we live in today. The world we live in today has the charter schools. They have 4 schools that they seek to brand all over the metropolitan area so that when families say, what should I do where should I send my children? They know that that charter school has a particular approach and brand that they can trust. Likewise, Ascent, as a management company, says, when we manage a school, we do this, that, and the other. We vet our teachers, we provide this type of curriculum, these types of materials, we have this type of discipline. We provide that product and service. And they're a management company. This world of school choice is far different than what this judge assumed. And the judge made factual assumptions that go far beyond common sense. When we talk about common sense and experience, we're talking about a judge's common sense to understand inferences within the bounds of a complaint as to whether those certain allegations logically will support a complaint. That's what we mean by a judge uses its common sense at this stage of the pleadings. Not that the judge makes statements like unvaried reproduction of a full legal name is not and never has been how school names have been used. It never has
We
been as a
ignore
broad
that-
standard.
Do we not all understand the University of Southern California is known as USC and the University of Virginia goes by UVA? And is that not just what the judge was observing?
No, that's not at all.
Referred to Central as an abbreviation for some high schools, that's not the same concept. That's fact-finding?
That is completely fact-finding and not at all. You know, look, the word central is a geographical location. I mean, the world, certainly I grew up in, I'd submit maybe the judge grew up in. I mean, we didn't have all this school choice. We went to a neighborhood-based school that normally had a geographical designation, and that's how it was referred to. And you didn't have these issues of intellectual property rights because you didn't have this level of school choice, which I would submit, and I know we're painting outside the lines a little bit. Yeah, I mean, about 25% of all Colorado children attend either a charter school or a private school. And so these intellectual property issues do matter, and it is much different than what this judge painted as a picture. And they are factual findings. They look at customary usage.
I do have actually a question.
Yes, sir.
For a license, does the licensor need to retain control over the quality?
I'm sorry, can you say that again, Your Honor? I missed.
Since Bob Bacharach Dry Cleaners, the use of Bob Bacharach Dry Cleaners to you, to characterize that conveyance of your usage, your right to use the name Bob Bacharach Dry Cleaners, do I need to retain control over the quality in order to maintain that characterization as a license?
I don't think quality is one of the conditions. Usually it's confusion in the marketplace, and there.
So a license, are you familiar with the term naked license?
I am not, Your Honor. What I would say is what we're looking at here is the licensing of a trade name, not a trademark.
That begs the question. So if a license, I don't want to belabor it because if you're not familiar with the term, you're not familiar with the term. But if a licensor has to retain quality control in order to maintain characterization as a license, and if Ascent had conveyed the right to use the trade names, even after termination of the agreement, I don't know how Ascent would be able to treat the conveyance of the right to use the trade name as a license, even though it uses the word license, and then a non-transferable license. I just question whether or not the use of the terminology was incorrect as a matter of law, and it was really an assignment, a transfer of ownership of the right to use the name, in my situation, Bob Bacharach Dry Cleaners. And if it was an assignment, you would lose, right? If it was an assignment of the right to use the name of the schools, then they would have the right to use whatever variant of the name that they would like to use, right?
No, Your Honor, that is not correct. And if I may answer. It's not an assignment of a trademark. There is a difference between trademark and trade name, Your Honor.
Okay, but an assignment is an assignment is an assignment. If it is an assignment of a trademark, are you saying that the new assignee of the trademark has no right to use any variations of the name trademark, even though that entity owns as the assignee of the trade name?
If I may, Your Honor, that is not our argument because we have never argued or contemplated that there was an assignment of a trademark. only a trade name. And if I may just squeeze this in here.
Argument is, right.
So what our argument is trademark stuff, a trademark is different than a trade name. And a trade name is a specific name that can be used for a specific school or a specific business, in this case, a specific school. Now, a trademark or a logo or advertising material may incorporate a trade name, or it may not. In this instance, the only thing that Ascent granted through mutual agreement of the parties was a trade name to be able to be used with the school itself.
Let me, I understand all that. But if I assign the trade name Bob Bacharach Dry Cleaners to you, I say, have at it. You're the assignee, you use it. And you use the name Bacharach Dry Cleaners. Have you deviated somehow from the right to use the trade name, even though you are the full owner, the full assignee of the trade name Bob Bacharach Dry Cleaners?
Yes, you have. And the reason why is, if you say, Bob Bacharach Dry Cleaners, show up here today, we got a nice logo, come join us. That is a trademark. That is not a trade name. Now, the name is being used as a trademark. The trademark incorporates that name. If you register with the Colorado Secretary of State or the U.S. Patent Office or your chartering authority as a school, and you say, I am the Bob Bacharach Dry Cleaners, that is my legal name, and that is the name of the entity under which I pay taxes and I register. That is a trade name.
All right, so what you're saying is that if it was an assignment of a trade name, you lose. But you shouldn't lose because it would be an assignment of a trademark. Is that what you just been?
When you say you lose, I'm
just trying to figure out how your answer fits into my question.
I'm struggling my best to help you out, Your Honor.
I asked you a question about an assignment of a trade name.
Correct. But you used, I would submit, your examples as part of that question were actually trademark examples, not trade name examples.
I know that, respectfully. I mean, I heard you say that. So if it was an assignment of a trade name, I know you're resisting the premise, but if it was an assignment of a trade name, Bob Bacharach Dry Cleaners, then they would have the right to use any variation you would have the right to use any variation of the name Bob Bacharach. You would be able to use Bacharach Dry Cleaners, Bob Dry Cleaners, whatever. But that's not, but you're saying that conveyance could not have been the conveyance of a trade name. It would be the conveyance of a trademark, right?
Correct, if it were used in that capacity.
So I'm just trying to figure out what your answer to my other question, how it relates to my question. So the answer to your question is that, well, if I assign Bob Bacharach Dry Cleaners to you, then that is the assignment of a trade name, and you would be circumscribed in your ability. You couldn't use Bacharach Dry Cleaners. You couldn't use Bob Dry Cleaners because it was the assignment of a trade name as opposed to a trademark. It was the assignment of the ability to use the exact same formulation Bob Bacharach Dry Cleaners.
That is correct, Your Honor. And I believe the trial court found that conclusion repellent and therefore included extrinsic evidence as a way to interpret the word use.
I understand. We're ready for the ability.
Thank you, Your Honor.
Good morning. May it please the court. My name is Eric Hall, and I'm here on behalf of Ascent Classical Academy Charter Schools and Land's End. And Your Honors, I'd like to pick up with the interpretation of the contract because these are Lanham Act claims, 3 Lanham Act claims, but they do turn on the interpretation of the contract. With all due respect to my opposing counsel, I want to direct the court to the places in the contract where it actually talks about what was conveyed to the schools, my clients, upon separation. So again, my friend on the other side says that nothing was conveyed except this specific name in its entirety without alteration. Respectfully, that's incorrect. If you look at Article 3, Section Q, that on Joint Appendix 94, that states that the financial, educational, and student records are all school property. So upon the separation, those items, the financial, educational, student records, went with the school. Similarly, Article 3R, the intellectual property provisions at Joint Appendix 94, so this is at the beginning of them, it recites there that all the intellectual property of the educational materials that the schools paid for belong to the schools. So if the schools paid for the curriculum guides, if the schools paid for, how to teach U.S. history, that intellectual property belonged to the schools, they could keep it. Similarly, on Joint Appendix 95, also under Article 3, Section R, it talks about the school actually has a right to continue to use the ACA, the Ascent educational materials, so long as the schools continue to use them in the regular course, i.e. as they had been using them prior to the separation. So again, even if some of the educational materials were intellectual property of ACA, Ascent, the schools could continue to use those as long as they were using them in the regular course that they had been using them before. Similarly, when you look at the termination provisions, Article 8, Section B2, and Judge Shelby, this is to your point, that B2 section says that the materials that were paid for by the schools and owned by the schools, that the parties agree are owned by the schools, like the desks, the computers, the basketballs, the gym mats, the uniforms, all those things, the schools get to keep them. So there's a separation, and the schools get to keep all that stuff upon the separation. All of that needs to be understood when you then look at that key provision at the end of Article 3, Section R, that talks about the school names. Because that last sentence of 3R that's so crucial here says essentially the schools the schools are assigned, Judge Bacharach, to your point, the schools are assigned this trade name, their trade name, and they can use it in perpetuity without any further payments to Ascent.
Why aren't those provisions of the contract that you just referred to about materials and that sort of thing, why aren't those just pretty clear exceptions to this rule, which is you can't use anything post-termination except the trade name that you already have. It's period, end of story. Everything else is off limits unless you pay us more money. For instance, if you're going to get new desks or new jerseys or new whatever, you're not going to be able to use anything other than this name, this trade name, unless you want to pay for it. So everything else we've told you under the contract, you can keep all this other stuff with our names, with our trademarks and trade names, but that's only for everything you have as of today or as of the end of the contract. So why isn't that the very simple way to read that?
Judge Morris, I think the simple way to read the contract is this is a contract that divided both intellectual property and other property that made it account for what the parties were going to have upon separation. And then upon separation, the schools were going to keep a substantial amount of things, and ACA was going to keep other things, and it could go sell its management services to other charter schools in other places, but the schools could continue to operate as they had been operating, including continue to use their trade names, their names, as they had been using those names, including with all the permutations and abbreviations that they've been using them before.
Doesn't seem to say to me, and to me, what you just explained, which is, yeah, of course they're going to keep materials. They're not going to have to buy new desks, new everything. But that's the end of that. If they do buy new post this, you got to compensate us for it, period. It doesn't seem that complicated.
Well, Judge Moritz, my point is the assignment, the grant of permission at the end of 3R says that the schools get to continue to use their names, and they are names, as Judge Gallagher.
Trade name, and in this case, the one we have here is Ascent Classical Academy of Douglas County, but It's in quotations. I
Sure.
think that's a reasonable reading to think that that is what you get to use, that trade name that you already have. It's not really conveying anything.
But that's right, but we get to use the trade name as we had been using it, which includes abbreviations and permutations of it. In
It
other words,
doesn't say as you have been using it. It has it in quotations.
correct.
If you're going to use it in the future, you're going to have to pay for it. If you're going to use permutations of that or other, or if you're going to use trademarks and trade names that don't belong to you, you're going to pay for it.
Well, again, Your Honor, I believe the quotation.
Saying, isn't it a reasonable interpretation? And we're at the motion to dismiss stage of the
Correct.
contract, that it divides before and after, just exactly like it appears. You've got a trade name, you can continue to use that, it's in quotations here. Everything else belongs to us, except what we've accepted out apparently in the contract. You know, that's already existing on materials, on physical property, essentially.
Yes, but Your Honor, if ACA's argument prevailed, then like Judge Shelby was pointed out, then essentially this grant of permission would actually be a prohibition because it'd be completely unworkable for the schools to then say, we need to now modify all these items that we own with the full,
You said
with the
that, you
full
said
legal
there's an
name.
exception for those. You can
Well,
continue to use those materials.
well, Judge Moritz, what I'm saying is the way the agreement actually reads is it essentially incorporates what I think of as a non-disruption principle. In other words, the schools get to continue to operate as they had been operating, and there's a separation, but to be forced to change all the instances of the
I'm
school's
saying
name
it's
with the full legal
I think you're
name.
agreeing that it's ambiguous. I mean, you two both have completely opposite views of this, and you may be able to go both ways, but it sure does seem ambiguous, and it's certainly possible it doesn't mean what the district court said it meant, and the district court did use evidence of custom, which was, you know, arguably not appropriate at this stage.
So I do agree with my friend on the other side in saying that one, interpretation of contracts are a question of law that this court can do, that any court can do. Facts don't come into that. And two, that there is no ambiguity in the contract. I think the contract very clearly indicates that the schools can continue to use their names as they had been, which means they don't need to rebrand.
Well, you may think that. I'm telling you, it may be ambiguous. And what is your answer if it's ambiguous? You, presumably, the motion to dismiss is improperly granted.
Yes, Your Honor. If this court believes it's ambiguous and believes that it needs to be sent down for more factual finding, it of course could do that. I don't disagree with that. But again, at the end of the day, it's still going to be a question of law as to what this contract means.
Well,
and what
the problem that we have with the question of law, as you say, is the district court went outside of the four corners of the document here and definitely used what he viewed was customary practice, which to me it goes way beyond common sense of the judge. What is customary practice? I don't know, but you certainly would need some evidence of that. In any event, that goes outside the four corners of the contract, possibly. And so we have a problem with the district court's interpretation.
Respectfully, Your Honor, I disagree. I think
I know you do. I'm just saying it is a problem to go outside and rely on evidence that's outside the four corners of the contract.
I think the court was entirely appropriate to say this is a question about a school name, and school names are used as a matter of common sense in a whole variety of uses.
He said customary and custom. There's a big difference between custom and common sense.
But anytime any court is reading a contract, it is allowed to consider all the various factors that Judge Shelby discussed, including saying, well, in a school name, how are names used? How are any names used? Names are used with abbreviations and permutations all the time. It's completely unworkable to think that anyone, including a school, is going to use the full legal name in its entirety without alterations every time it uses a name. And that was the only, just like Judge Shelby was saying with UVA and USC, or with this court. I mean,
You didn't even make this argument about custom below, right? I believe you didn't.
Your Honor, I said that the court could read the contract.
Right, but you did not make this argument about custom, and I assume you stayed away from it for a reason.
Your Honor, I did make the arguments that said that when a court is interpreting a legal agreement, that it can use its common sense, just like
I'm
Iqbal
saying,
said, just like
I'm
Iqbal,
saying
just like
custom
Iqbal.
here.
Well, just like Iqbal says, the question is plausibility. The question is, are these Lanham Act claims plausible? And my argument has always been the idea that what the parties agreed to was that this particular trade name must be used in the full legal name in its entirety without alteration every time a
I
name is
understand your
needed
argument, but
is
that's
not- is-
different than what the district court did here. You did not argue below that you district court should consider the fact that courts use all, or that schools use all kinds of variations of names. You didn't talk about custom and usage, you talked about your view of this contract, basically.
Because, Your Honor, I think that's all that's
Confines of the contract is what I'm saying.
correct, Your Honor, and the district court.
Is that what's in quotations, you can use any of those words within the quotation, right?
Because the use of,
And saying, schools all the time use shortened versions, nicknames, all kinds of stuff. That's a custom versus saying, my position is those words within the quotations are what we can use, well, permutations that we can use.
Quotation marks are one indicator of meaning, Your Honor, just like context and everything else about a written legal document are indicators of meaning. And I think it was entirely appropriate for the court to say, I'm going to consider the quotation marks and the context and the other provisions in the contract all to make a commonsensical determination that it would be unworkable for the schools to use the full legal name every time. Therefore, that is an implausible, these are implausible Lanham Act claims. And again, when you keep in mind that the underlying principle of the Lanham Act is unfair competition, this case does not go to unfair competition at all. The only thing that happened here is the parties separated and the schools continued to operate as they had been operating using their names, which again, they own pursuant to 3R, and they said, oh no, these are trademark violations because you have to use the full name every time without alterations.
What work do the quotation marks do in the contract then? What's the purpose?
They distinguish them from other schools that might open in other locations. So the complaint discusses how these parties work together to open a series of schools, a network of schools. Douglas County first, Northern Colorado second. They tried to open one in Boulder, it failed. They tried to open one in Durango, it failed. They opened one in Grand Junction and in northern Denver. The quotation marks indicate the names for the successful schools, those are the trade names, and those names the schools can keep and continue to use on assignment as they would like, as they had been using, but you can't go and get another school in Colorado Springs or in Pueblo or in Greeley and call it Ascent Classical Academy of Pueblo. And if you do, then there would be a question between the parties as to whether that would be some sort of violation of either the contract or trademark law. But again, the quotation marks, if what the parties intended was that the schools were going to have to use the full legal name without alteration, they would have to use more than quotation marks. They would need to say things in the termination provisions like, and all these items that you schools get to keep, they all need to be rebranded. And all the intellectual property that you have, that all needs to be rebranded too. Because you have to use that full name, and like the court observed, it is commonplace for not only names to be used in abbreviations, but also to schools to have lots of different permutations of their names on all their items. And that would be the opposite of what the parties agreed to here. And so the court correctly concluded that is an unreasonable reading of this contract, and that is an implausible, those are implausible claims, and therefore the motion to dismiss was granted. And Your Honor, I think that was the correct reading, and this court should affirm. Unless the court has any other questions, I will sit down.
I do have a question. So you earlier, and I don't want to beat a dead horse, but I want to get to this concept of distinguishing or not between an assignment and a license.
Mm-hmm.
So there's two buckets, assignment versus license and trademark versus trade name.
Mm-hmm.
If the conveyance was an assignment, not a license, of a trademark, would that circumscribe the school's ability to use a variation of the name in the quote marks? Or would it be affected by, assuming that it's an assignment, not a license, by the characterization as a trademark versus a trade name, or would it matter?
So let me answer both, Your Honor. First, the assignment and the license. So as to the assignment, if it had been an assignment of a specific trademark in that hypothetical, then arguably that might have constrained the schools and their use of it, because the schools would have known this is the specific trademark, and we cannot vary from this trademark that's been assigned to us. That's not what happened, right, at all. What happened was, I think the end of 3R was an assignment of a trade name, and they said, schools, you can use, we're assigning you your name for you to use without further compensation to us, and so you can go ahead and use it, which means the schools reasonably thought, oh, well, then we can continue to use our names as we had been using our names, which would include things like, I'm gonna say on my basketball, Ascent-DC, because writing Ascent Classical Academy of Douglas County on every basketball and gym mat and school uniform and athletic uniform is just unworkable. So the schools could continue to do exactly that. As to your license question, Your Honor, yes, you're right. When you look at that last paragraph of 3R, the beginning talks about licenses. And when the parties were still working together, then ACA had a license to us that we could use any and all of their trademarks or trade names, whatever they were. Once the agreement terminated and that license ended, that's fine. But that beginning about licenses is different than the end of 3R that says specifically that ACA granted to us our trade names that we could then use. And
So it originally was in fact a license because Ascent did exercise quality control, had control over the conveyance of both the trademark and the trade name, but once the relationship soured and terminated, the last sentence you're saying transformed the relationship into one of an assignment and no longer a trademark, but a trade name.
not quite, Your Honor. I'd say it just slightly differently than that. What I would say is when the parties entered into these management agreements together, they understood that last paragraph of 3R, as it's written, was that when the parties were working together, then there was a license. But once the parties separated, then the ACA said to the schools, you own the names. You own your names. Go ahead and use your names as you want, because we don't want to make you rebrand. If they'd wanted to make us rebrand, then these would have been written differently. But they said, just continue to use your names as you had been using your names, just like you can continue to use your educational materials, your student records, your basketballs, all those things that belong to you. You can keep those and continue to use those. That's all consistent, and that is inconsistent with my friend's reading, which is, oh, you get to leave, but every time you use your name after we separate, you must use the full legal name in its entirety without alteration, which is completely unworkable. And therefore, I believe, an implausible reading.
Okay, thank you.
Thank you.
What I'd like to do is, I mean, both sides have gone over time. Nobody's fault. We've just had a lot of questions. But I am going to go ahead and give you a minute and a half. Ask you not to, you don't have to take it, but if you have a minute and a half of rebuttal to clarify anything, you're welcome to do that.
Thank you, Your Honor. Being a lawyer, I will happily embrace any additional time I can have. I would just like to focus on the trademark versus trade name, and I think there's some confusion. What we tried to do in our brief is sort of demarcate the differences between the two. And a trademark is a sort of a source identifier. You use it to brand yourself with a product or a service, or if you use a service mark. Trade name is more of a specific name for a specific business. It's a business identifier. So the import of it is you don't put, if you put a trade name on a basketball, you're not using it as a trade name. That's a trademark. It's out in the public. It has been released into the wild where people can see it and use it and associate it with quality or lack of quality or certain characteristics. And the reason why is we would submit, a trade name in this instance. The charter school is chartered by a chartering authority under a specific business name. And that business name is Ascent Classical Academy of Douglas County or the other Ascent Classical Academies. And if that name changes, it requires certain cumbersome regulatory involvement as well. So there's a real reason for that. But when it comes to intellectual property as a whole, and my colleague certainly correctly identified other carve-outs, the structure is large amount of the IP goes to Ascent, except for very specific carve-outs. Thank you for the additional time, Your Honor.
All right, thank you both for both sides. I think as in the other cases, I think your briefing and arguments were excellent. Though we interrogated you pretty good, but at least for myself, I'm trying to understand it. And you both were very, very helpful. This matter will be submitted. We'll go to the last case, is Drexler versus Weiser, 25-1173. All are splitting three ways. My sympathies to whoever has picked the short straw and is going last. Good luck to you. But split your opens. Y'all collectively have 15 minutes. We'll hear from the appellant.
May it please the court, Michael Francisco on behalf of Appellant Regina Drexler. The First Amendment undoubtedly protects speech that is published about non-threatening issues, even if those issues are embarrassing. Unfortunately, Colorado's laws make such speech subject to punishment. And any Coloradan could bring a challenge on a pre-enforcement basis to such laws. Ms. Drexler is such a Coloradan, and in addition, she has a clearly objective and reasonable basis for fearing additional punishment for engaging in such speech based on the extensive record of what happened to her in Colorado. This case needs to be remanded so that the issues can be decided on the merit for these claims that had been brought, and the district court, with all due respect, has made a couple fundamental errors. The first error, Your Honor, is that the district court seemed to view this case as a third bite at the apple, noting that the roads had already been driven in state court. However, what's left now is a prospective challenge, meaning what has happened in the past is not being collaterally attacked. There is no more Rooker-Feldman issue. This is a garden variety, if I will, pre-enforcement challenge that's facial based on the First Amendment. And the district court seemed to fail to apply that even-handedly through the analysis, and related to that, the district court failed to account for the breadth of the claim here. The claim is not just on behalf of Ms. Drexler, and it is not limited to just publications about the relationship with RB. It is on behalf of all Coloradans. These are claims for facial declaratory relief, and it is about a desire to publish about other relationships, not just the relationship at issue. And for that reason, the district court's analysis simply missed the mark on what is happening here. Second, the district court really failed to appreciate that. I meant to signpost it earlier that it is about claims that reach others, not just claims between Ms. Drexler and the individual RB. So we think it was error to dismiss it, and as this panel contemplated in the prior order and judgment, the claims need to be decided on the merits at this time. I welcome this panel's questions. Otherwise, I will continue to argue that under the 11th Amendment analysis in particular, the district court simply failed to follow this court's many precedents applying the exception to Younger for federal claims against officers, state officials, when they're in their official capacity and they have some enforcement connection. And here the Attorney General quite clearly has an enforcement connection. He has an express statutory duty under the protective order statutes. It's both, yes, Your Honor. As a peace officer, there's an express statutory duty for the Attorney General. And we think that that distinguishes this from the instances in which the courts tend to say that the Attorney General can't be named as a representative of the state as a general matter or for the general enforcement of state laws. This is a specific statute that gives that authority to peace officers, including the Attorney General.
A trainee, he or she just passes the academy, it's their first day, and, they get the certificate, and they say, congratulations, you are now a peace officer of the United States. Let's just say that's me, Bob Bacharach. And so then I get sued in my official capacity as a peace officer who is charged with enforcing the emotional distress stalking statute, the violation of a protective order. Can I be sued simply because I am a peace officer, just like the Attorney General?
We think you could, Your Honor. That, of course, would be perhaps what the outer limits of a pure peace officer connection would be. But here, as we outlined in the briefs, there are additional connections between the Attorney General and the protection order statutes, such as the conduct that occurred in the Castleman case at the Supreme Court, and the fact that he can be specifically appointed to act as a DA, if you will, as a prosecutor.
Right, but that did not happen in this case, right? Not in
No.
There was, and the only two instances in that scenario were when there was a vacancy in the DA's office. Obviously, you can't have two DAs in the same county, right?
Yes, Your Honor, but go ahead.
You go ahead.
The 11th Amendment immunity exceptions don't require the state prosecutor to have exclusive authority.
But they do Hendrickson does require a particular duty to enforce, doesn't it?
Yes, we think the statute clearly satisfies the particular duty as to the Attorney General, number one. Number two, I would point out that the DA doesn't even raise 11th Amendment immunity as to the criminal statutes here.
I'm not talking about the DA. I'm still on the Attorney General. But the Attorney General, you've identified two instances, two scenarios in which the Attorney General has a duty to enforce. One is they have the same status as this new recruit, Bob Bacharach, a new peace officer, and the Attorney General has that equivalent duty. I don't know that I would have a particular duty to enforce anything unlike any other peace officer in the state of Colorado. I don't know the Attorney General would, if we're only talking about classification as a peace officer. And then the second scenario is a good argument, but it seems academic, that if there's a vacancy in the DA's office, the Attorney General can have a duty to enforce, not because they're the Attorney General, but because they're the interim DA, and that doesn't happen. So I'm wondering where the particular duty to enforce falls on the Attorney General.
Well, I think the particular duty comes from the statute we've identified, 13-14-107. You have to use every reasonable means to enforce it if you're a peace officer. And with respect, I think the particular connection here, just looking at the Attorney General, is certainly greater than the connection the Attorney General had in Kitchen versus Herbert, when this course easily adjudicated those claims without the 11th Amendment immunity applying. And it's also greater than what you would find in the consumer Data Industry Association case, which talks about how it doesn't need to be exclusive. We recognize there are multiple peace officers, and of course, you can name multiple defendants, as we have done, as many defendants do for the 11th Amendment purposes. I think, practically speaking, the Attorney General is the most common sense defendant to be named in a case like this. For similar reasons, a different statutory scheme, but structurally similar. The Attorney General is the lead defendant, or a defendant certainly, in the 303 Creative, Masterpiece Cake Shop, Childs line of cases, along with other state actors.
How is this case different than Free Speech Coalition, where we said the Attorney General's general law enforcement
Yeah.
authority was just absolutely not enough?
Well, Judge Moritz, I think that the statute we just talked about is specific to protection orders, and that was entirely lacking in Free Speech versus Anderson, and we don't contest the well-recognized rule that an Attorney General can't have a general duty to defend the law for 11th Amendment purposes, but these are two specific...
That was the same issue we were dealing with in terms of, is there anything more here than the Attorney General's general duty to defend the law?
Correct.
I don't see any difference between that case and here. You're relying on the general duty to defend as a peace officer.
It's not a general peace officer duty. It is a duty specific to the protection order statutes. That peace officers have a duty under 1314-107 to enforce these particular laws. Now, there are lots of peace officers, but that statute, and that's entirely lacking in Free Speech versus Anderson, this is the definition of a specific statute. It applies to the universe of protection orders.
So pretty much any criminal statute in Colorado which I assume peace officers can enforce, any criminal statute, that they're not going to be subject to 11th Amendment immunity because they have a general duty to enforce. Or you're calling that a specific duty?
We think it's
Every single criminal statute in every peace, anybody designated as a peace officer of any kind, somebody, working in the forest or somebody, everybody, they're a peace officer.
No, I think what we're saying is you would have to have some connection to that particular statute. I'm not familiar with the general freestanding.
It's a special relationship then, because a peace officer is an extremely broad category under Colorado law. I presume peace officers can enforce most of the criminal statutes. Maybe I'm wrong about that. I don't know.
I'm not certain about that either.
Just saying, you're advocating for a very broad.
No, if peace officers can enforce criminal statutes in a specific way, they'd frankly be no different than DAs. And DAs don't even try to raise 11th Amendment immunity, even though there are many DAs and many criminal statutes.
Shouldn't they be different than DAs who have a specific connection?
No, I think the specific connection, they're obviously different in practical ways from a DA, but the 11th Amendment is concerned with some connection, not an exclusive connection, and you don't have to name only one person with a connection to the law, which is why we have multiple defendants here. And so I think if you don't think that the Attorney General is the most appropriate defendant, you would have to look at the district attorney, certainly as to the criminal statute where he doesn't even raise 11th Amendment immunity. Your Honor, I'd like to take a step back and consider the nature of the speech restriction that Colorado's laws are imposing here, because we think it's frankly quite substantial. What you have are a series of laws that have been used against Ms. Drexler to punish literary speech about a relationship that is non-threatening. That is core First Amendment speech, and what Colorado has done, which is what we think violates the First Amendment, is simply label that speech, non-threatening speech about a relationship that is indirect, not even made directly to a person, as being harassment and therefore subject to severe restriction. We're talking about a permanent protection order with criminal consequences. It is a rare case in which you have a civil order that has automatic criminal penalty.
For speech?
Yes.
But isn't that directly contradictory to the prior order and judgment that said Is it credited? Not, well, if you disagree with the prior panel opinion, certainly we're fallible. But in the collateral, in the decision on collateral review by the state judge, but we have not only a prior panel opinion saying that that Ms. Drexler cannot be punished because the protective order may, even if you credit the impetus for the protective order itself, the prior opinion said that, as I recall, that the protective order itself does not regulate speech. And that was, in fact, not out of a vacuum, but that you had a state judge that was interpreting on collateral review the protective order itself that said exactly the same thing. How do you deal with that?
I'm glad you asked, Your Honor. I'll try to be brief. I'd like to reserve a little bit of time for rebuttal. This circuit's prior order and judgment is in a habeas context in which the question was different than the question here. The question was whether the orders, in this circuit's view, whether it restrains somebody's movement, by analogy, so much that it created a habeas violation. Here, there is a broader and different standard that applies to pre-enforcement chill of First Amendment activity. So you cannot disregard the court's statements, their explanation of their orders, which in 2015 and in 2018 very clearly indicate that they're restricting Ms. Drexler's ability to publish speech about RB. Now, a third district court decision in state court about a state collateral attack dismissed that. We think it was erroneous by saying that it only restricted contact. That's wordplay in the sense that contact was defined to include speech that is a published literary essay that's indirect. And so it was, I don't think, the issue that was before this court before, and in any event, that state court decision is not binding. So if she goes back and asks for dismissal of the protection order, she can't point to that decision that this court did in the county court and say that you have to find that this doesn't restrict speech because it's completely not binding on the county courts. And there's additional reasons in the brief, but we think it's particularly strong that that doesn't defeat the broader category of chill for the First Amendment.
The podium. So when the prior panel considered the earlier version of this case and said that the protective order has to be evaluated based on the terms of the order, and the terms themselves don't restrict Ms. Drexler's future writings, that's what? Is that dicta? Or is it just wrong?
First of all, it's not the same issue because habeas is talking about her restraints on movement, where the order itself, arguably you could limit it to just the order. But when you're talking about First Amendment chill, this court has been very clear that like in Bantam books, there are, if I could remember the quote.
So it's both incorrect and irrelevant.
I would say, first of all, it's irrelevant and that's a different legal issue. But we do disagree with it as a matter of interpreting what would happen in state court. But if you really step back, there's 200,000 reasons why Ms. Drexler still has chill. She's been fined $200,000 for engaging in petitioning activity to try to overturn these protection orders that limit her speech. So she's clearly subjectively and for reasonable basis chilled from going back a third time without a federal court declaring the First Amendment rights at issue here. Thank you.
Good afternoon, and may it please the court. My name is Joseph Michaels, and with this court's permission, I'll speak for about 8 to 9 minutes on behalf of the state defendants before I turn it over to my colleagues on the table. Thank you, appreciate that. We're here today about a protection order that does not even concern, let alone prohibit, the appellant's actions that she wishes to engage in on a personal and on a First Amendment basis. As this court just discussed with my friend on the other side, the protection order does not restrict or even prohibit her ability to write, publish, or perform. My colleagues want to make this about a First Amendment issue, but before they do that, The state officials, the attorney general, the state court administrator, and the state judges, and the county judges for that matter, are immune from suit under the 11th Amendment as arms of the state. So before she could even get there, she has to pierce that sovereign immunity and establish standing. The district court here rightly rejected appellant's claims and dismissed the complaint. And this court should affirm on 3 different grounds. 1, the state defendants all have sovereign immunity. 2, the ex parte Young exception to sovereign immunity doesn't apply specifically because none of the state defendants have a particular enforcement authority or a demonstrated willingness to do so. And 3rd, particularly with the judges, they are not adverse parties under the 11th Amendment and under ex parte Young, and more recently Whole Women's Health versus Jackson, which is cited in the briefs. Now, I do want to very briefly touch on this court's last opinion from this case that talked about the protection order. And it talked about how, as Judge Shelby pointed out, you look at the terms of the protection order, and the terms of the protection order are conduct-based. Do not go within a certain number of feet of the protected party's work, the protected party's home, and the protected party's children. Nothing about that is First Amendment based, and nothing in the protection order, as this court recognized previously, prohibits the appellant from writing or publishing. Under the 11th Amendment, state officials sued in their official capacities are immune from suit as arms of the state, and that applies to judges equally to state officials. A plaintiff, of course, can seek prospective relief against a state official for an ongoing constitutional violation, but to do so, she must establish a particularized enforcement authority of that state official and a demonstrated willingness to do so. And the reason for that is it harkens back to the standing redressability prong, which is just simply not met if a plaintiff seeks relief against a defendant with no power to enforce a challenged statute. And here, the Attorney General, the state court administrator, and the judges don't have any particularized enforcement authority for any of the challenged
Why isn't
statutes.
the allegation that a state attorney general is a peace officer, and peace officers are specifically permitted to enforce this particular statute specifically? Why isn't that different than, for instance, in Free State Coalition, which is our more recent case on this issue, where we had a private cause of action against private entities, porn sites basically, that were needing to get ID, and if they didn't get ID, you'd have a private cause of action. That's not a criminal statute where you have a specific essentially delegation to peace officers to enforce it. Why isn't this different than that?
Thank you for the question, Your Honor. In Free Speech Coalition, the department and the commission oversaw the program for age verification, but they didn't have a specific enforcement authority.
Right.
The same is true here with the attorney.
Private cause of action that the statute set up.
That's right. And here,
Different than what we got here.
here it's a little bit different in terms of structure, but not in terms of the particular enforcement authority. Here, the Attorney General does not have the authority to direct acts of others or even have a general enforcement authority, nothing more than a general enforcement authority and a statutory obligation to provide opinions to officers and commissioners generally. And to take a step back further, yes, there's a peace officer statute that directs enforcement of the laws, but there's an Attorney General statute that has more specific requirements for what the Attorney General can and cannot do. And with respect to the district attorney's authority, the district attorneys have the particularized enforcement authority of all the criminal laws. The Attorney General does not have just a roving mandate to go in and enforce criminal laws to supersede or take the place of the district attorney's authorities. And that's something that this court actually looked at in the Kitchen versus Herbert case, and it recognized that in that case the AG did have the authority to supervise and oversee the district attorney filings, and that's why there was a particularized enforcement authority there. We don't have that here. The district attorneys have a separate particularized enforcement authority in a separate statutory provision.
Well, the Attorney General in Herbert just said as much, right? I mean, it wasn't really an issue that was addressed. The Attorney General just said, I have the authority, and didn't contest it. Isn't that right?
That's also true, but the statutory framework, Your Honor, was also different based on, at least from what I understand, based on the assertion made that under the statutes at issue there in Utah, I believe, the Attorney General does have that superseding authority, or supervisory authority, excuse me.
What about, you don't argue that the Attorney General can't find itself in a position of having to enforce this statute in the appropriate circumstance when it's designated by the governor as a temporary DA? If a case arose involving this statute, the Attorney General would enforce it. True?
If the Attorney General was appointed by the governor to enforce the statute, that would then potentially satisfy the particularized enforcement authority, but that isn't the default, and that only happens in the situation where the governor would appoint him under the statutory provision. Otherwise, it's just a generalized enforcement authority, and as this court recognized repeatedly, but most recently in Edmondson, merely because an Attorney General has a duty to prosecute all actions in which the state has an interest is not enough to make him a proper defendant in every such action. And I think also that goes to the point of showing that the particularized enforcement authority is in fact vested in the DAs, and it takes an act of a governor's executive order to tag the Attorney General in order to start a prosecution in those circumstances. I want to talk very quickly about something that was made with a much more strident argument in the reply brief than I think has been addressed in the briefing up to this case. And that's this idea of the Attorney General as counsel for agencies and that giving the Attorney General particularized enforcement authority. And that's certainly just not so. When lawyers for the Attorney General's office represent a state agency as a client, they do so out of a general statutory duty that's specifically found in order for the Attorney General to appear on behalf of the client agency. They're not appearing as an enforcer of the law. They're not appearing on behalf of the Attorney General. They're appearing as any lawyer appears on behalf of a client. They serve as its agent, consistent with the Colorado or any rules of professional conduct 1.2, where a lawyer must abide by the client's wishes. So applying the ex parte Young exception, as the counsel on the other side advocates for doing, in a situation where the Attorney General is simply counsel for an agency, representing an agency, would amount to essentially nothing more than a generalized finding of the AG having authority to appear. And let me give you an example of sort of why that doesn't track as a matter of logic. The Attorney General, one of the client agencies the Attorney General's office represents is the Office of the State Public Defender. But there's no world where the Attorney General gets up and represents defendants in criminal proceedings because there's no particularized authority to do so. But that doesn't change the fact that the Attorney General does in fact represent the agency in civil actions as a general principle. And that sort of dovetails with this idea that it was raised in the 303 creative opinion from this circuit. That doesn't suggest that ex parte Young applies. In that case, much like the Kitchen case, the 10th Circuit described Colorado as having conceded that their Attorney General had enforcement authority, at least limited for that particular statute, Colorado's anti-discrimination statute. But that was in the context of traceability for standing. And traceability for standing is different than the particular duty to enforce. It's about a little over the time that I want, so unless anybody has any questions specifically for me, I'm going to cede my time.
Go ahead and stop the clock. No, good, thank you. Okay.
All right. Thank you. We ask that you affirm it.
Good afternoon, Jack Peters. I'm here on behalf of District Attorney Walsh. Just to assuage your nerves, my third colleague is not arguing. So.
I didn't mean to scare you all. Sorry.
And so I think you've already heard a fair amount about the panel's prior decisions. I'm not going to belabor that. What I would like to focus on that's really relevant to District Attorney Walsh is the declaration that was filed. And I'm happy to talk about the later declaration that was also filed. But I think the key point here is that I'm not sure what else the district attorney can say, really beyond saying, we will not prosecute you for First Amendment activity. The district attorney can't say we won't prosecute you for anything because there are lots of crimes that don't involve First Amendment activity. There are lots of ways to violate these two statutes that don't involve First Amendment activity. All the district attorney can disclaim here is prosecution for protected First Amendment activity.
counsel raises an interesting point, that, you know, generally we look at standing at the time that the complaint is filed and a declaration, both declarations were filed after the filing of the complaint, the second one quite a bit later.
Sure.
Is that a problem?
Let me focus first on the one filed in the trial court. The issue there is that the district attorney had no idea who the plaintiff was, no idea what this issue was. The district attorney does not just walk around filing declarations in every lawsuit anywhere just in case she might become a party later. That just doesn't make any sense. The district attorney was named as a defendant, and that was the first time the DA's office ever heard about these issues. I mean, there are a lot of people in the city of Denver. The DA does not regularly audit, might I want to prosecute this person, right? That's just not the way the office works. So this is not something that was on the DA's radar at all. Once the DA was named, I think it was about 2.5 months between when the DA was named and when that declaration was filed. I think that's relatively quick.
Well, I will say that I understand you made that argument very, very well today and in your brief. How, however, do we reconcile that common sense argument with our case law and the Supreme Court's case law that says you evaluate standing at the time that the complaint is filed?
I think you can reconcile it just fine because the facts are what they are when the complaint was filed. Now,
Just plain devil's advocate, isn't the problem that to determine whether or not there is an imminent threat of injury for purposes of standing, can a district court or a circuit court look at a declaration that was filed post-filing of the complaint to determine at the time of the filing of the complaint whether or not there was an imminent threat of
well, I think the issue there is there's a long line of 10th Circuit cases discussing prosecutors' disavowals. Some of those are filed after the fact, and that holding would say a prosecutor can never submit a disavowal after filing, and that is just not consistent with this circuit's case law. There are several cases in which that happened. Now, if the DA had been named on day one, and 3 years later we thought, hey, that would be a great idea, let's file that declaration. Sure, I'll spot you that would be a problem. But that's not what happened here. So I think the issue is, yes, as a general fact, you're looking at the facts as they exist at the time the complaint is filed. And that's true for all the allegations. But some things, like this kind of disavowal, by their nature, it is not possible to know about them before the complaint is filed. So it would basically write out the opportunity to do that entirely.
Well, the disavowal may still be relevant, just not for a standing inquiry. I mean, it may present issues on the merits or the ability of a petitioner to satisfy their claim or its summary judgment. So it's not all is lost. It's just a question of whether it's a special exception to the timing rule.
I think that's right. I would just go back to saying, I think that would be that would conflict with this circuit's case law in which there are disavowals filed after the lawsuit has been filed. So that would create I mean, I think that would undo prior holdings, and that would change this circuit's law, which I don't think would be appropriate here. And I think that it's pretty clear cut that prosecutors in a situation like this, where there is this specific issue of credible fear of prosecution, can disavow prosecution, and that has happened many times, and there are many cases where it's discussed. So I understand the kind of writ large legal issue, but I think as it has actually been handled in this circuit, that's not how it's been handled as a matter of fact, as a matter of historical precedent. I'm happy to answer my questions if you have them, otherwise.
Okay, thank you.
Thank you.
Matt, does the appellant have any rebuttal time?
No, Your Honor.
Okay, I tell you what, even though you're out of time, I'm going to give you 30 seconds. I know it's not a lot of time, but it's 30 seconds more than you had. And that's just if you have one point or that you can do very briefly.
Thank you, Your Honor. I'll go to the last issue of the disavowal because I think it's important. The timing issue we think is critical and is in the briefs. However, The disavowal doesn't save the defendant's position because it's too generic. To say that if it's determined to be a First Amendment speech issue, we won't enforce it, is not the type of disavowal that the courts have accepted, and that makes perfect sense. It's effectively a prior restraint on speech. The whole problem here is that the county court said publishing literary essays is harassment, and regardless of what the First Amendment says, you're going to be punished for it. So it doesn't count as a disavowal to say that we will follow the First Amendment. The best case on that is probably the Duran-Patterson Christian Academy one, and I would point to the Holder versus Humanitarian Law. These are both cited in the reply brief, that the disavowal has to be for specific conduct, and that's the last thing I will say. The disavowal of the DA here is only about RB, and we have claims that are far broader than RB. Thank you.
This matter will be submitted. Court is adjourned until 8:30 tomorrow morning. I do want to compliment both sides. I thought your arguments were excellent in your briefs and today on both sides. Thank you both.